Morning, Mr. Hardwick.
Morning, my lady. Morning, my lords. I had got to paragraph 86 of our skeleton yesterday. That's page 75 of the core bundle, in the application of the fiduciary duty test. I had also, we ended yesterday at about 1 o'clock, discussing the suitability document, which, as the court is aware, is the document that more than any other document is now relied upon by the appellants in support of the fiduciary duty and disinterested duty arguments. But in view of the final exchanges yesterday and a development after the hearing yesterday, I should provide both a recap and a potential correction. The recap is this. The suitability document, which is of course that at tab 11 of the supplemental bundle of Johnson, page 37, was a document disclosed by Mr. Johnson. It was at tab 6 of the trial bundle before Deputy District Judge Sandercock. It was entitled, it was in a batch of papers called Claimant's List of Standards, Disclosure and Documents. It was page 60 of the 218-page trial bundle. We understand that Mr. Johnson obtained it from the Trade Centre Wales in redacted form. As to the role, or rather the complete non-role played by that document in the trial and the appeal below, neither counsel mentioned the suitability document in their skeleton arguments for trial, neither referred to the suitability document in cross-examination, or mentioned it in their closing submissions. When that one then looks at the judgments, Deputy District Judge Sandercock does not refer to the suitability document in his judgment, nor does His Honour Judge Jarman, KC. So that's the suitability document. As to the so defined capital D dealer disclosure document, the court will also recollect the witness statement of Mr. Irving of the bank, paragraph 10, in relation to what he defined as this dealer disclosure document, and the written evidence that he believed the dealer would have given to Mr. Johnson this document, which would have explained that the dealer may or would have received commission, but then says, I've been unable to find a copy. Now, the court will also remember that I took the court to the bank's attempt to cross-examine on this witness evidence, which was met with an objection that this is a document that has not been produced. The cross-examination, in any event, proceeds. As to the judgments, Deputy District Judge Sandercock refers to dealer disclosure document, but lowercase, at paragraph 21M of his judgment. He says, in recording Mr. Johnson's evidence, quote, I did not read the papers before I signed, including the dealer disclosure document, but then makes no further finding in relation to it. His Honour Judge Jarman did not refer to the document by name, but remitted the unfair relationship question back to the lower court for, and again I quote, for a finding on whether disclosure was made by the dealer. So that's the recap. The update is that in exchanges with your ladyship just before 1 p.m. in relation to the question as to whether what the bank called the dealer disclosure document was the same as the suitability document, I gave the answer that I had instructions that that was, and indeed is, or rather was at 1 p.m, the bank's understanding. So that in this case, the manner in which the Trade Centre Wales complied with its contractual obligation with the bank to make disclosure was by the sentence in the suitability document on the second page. We do not charge a fee for handling your application for consumer credit, but we may receive a commission from the product provider. My lady, that was my instruction and my understanding at 1 p.m. yesterday. However, there's an update. Yesterday afternoon, the Trade Centre group, which had attended the live stream, contacted my instructing solicitors, Evershed Sutherland, to explain that in fact the Trade Centre Wales had a much shorter document called the initial capital I, disclosure capital D, document capital D, IDD, which would have been presented to the customer quite some time before the suitability document was completed. So my lady, my answer on instructions that the so-called dealer disclosure document was the same as the suitability document may have been incorrect. Because if, but it's of course an if, Mr. Johnson had been provided by the Trade Centre with what's called this initial disclosure document, that presumably would be what Mr. Irving had in mind as the dealer disclosure document, the document by which the dealer made disclosure.
So, Mr. Hardwick, the suitability document precedes the selection of the lender. It says we're going to search all these lenders and we'll advise you which is in your best interest.
We will be looking at it just in a minute. When I come to the detail of the suitability document, you will see that by that stage, Firstrand is already a selected lender. It's got a time tag on it at 1511. I will be looking at it carefully.
Well, thank you. That'd be great.
But I was very keen to provide this clarification in view of our exchanges yesterday.
No, thank you, Mr. Hardwick. Well, I mean, I'd already formed a provisional view that they couldn't be the same document for various reasons. But it does leave us with this rather unsatisfactory situation that it has come to light in the Court of Appeal for the first time what the this IDD has suddenly been mentioned, and yet when Mr. Johnson went back to the dealers to find out what it was that he was given just the other document.
My lady.
I'm a bit surprised that he wasn't provided with a copy of the so-called dealer disclosure document, if such was the standard document that was provided.
My lady, yes.
It's all a bit of a mystery, isn't it?
It is a bit of a mystery. I was obviously anxious to correct what I say may have been a wrong answer yesterday. But I should also say that, as the court would expect, we immediately provided the documents we were given by the Trade Centre to the appellants. In fact, there's not only an initial disclosure document, also an SDD, a standard disclosure document, which looks a little bit like the suitability document but isn't the same. But let me be absolutely clear, for our part, we do not at this stage, mid-appeal, on day 3 of this appeal, seek a fresh evidence application.
No.
And of course we don't, because most particularly we don't actually know whether any of these documents were provided to Mr. Johnson.
Well, this is the problem, isn't it? We've got a situation in which your clients, for entirely understandable reasons, haven't got a clue what the dealer gives to the customer. At the end of the day, you're reliant upon them. You can only do, and I mean, this is a point that you make. You do your best to make sure that the information is disclosed, and there's no more that you can do, and therefore, why should you be held liable as accessories? I get that point completely. We then have evidence at the trial where your client says, well, I believe a document would have been given. The witness says, I don't know if I was given a document or not, but I didn't read anything that I was given. He's cross-examined on the basis that he can't say whether he was given the document or not, and he accepts that he can't say one way or the other. So at the moment, there's no evidence that he was given any document, other than possibly the dealer disclosure document. At the moment, I'm not even sure there's evidence he was given that.
He was given a suitability document, my lady. He signed it.
Of course.
That's right.
Thank you, Mr. Weir.
That is
Yeah.
right. It is a
So
sign.
we can at least...
It's an interesting issue, but not that interesting an issue, my lady.
Yeah, we can at least infer that some disclosure was made in the
More than
sense
fair,
that...
my lady.
Yes, yes.
And we accept it's a signed document. Our first reaction, if I might, when we saw it in this appeal, was, goodness, this is a new document. They would need a fresh evidence application. We then discovered it was page 16
actually given in the disclosure,
trial
yeah,
portal.
yeah.
So it was there in the trial.
And it could easily be worked out that it had to have come from the dealer because of the redactions.
Well, indeed.
Yeah.
Indeed. The only thing I'd add on the redactions is we approached, I say we, grandly, Evershed Sutherland's approached Trade Centre Wales last week to try to get an unredacted copy, and were not able. They were not prepared to provide an unredacted copy. And there's no criticism of that, but just so your ladyship understands.
But the evidence before the court was a bit misleading, wasn't it? It says, because of the passage of time, we've been unable to locate the document. In fact, the truthful answer is we've never had the document. We've no idea what it said.
My lord, I think that's probably fair. All I would say is that I've been told that is a sort of identikit paragraph in the bank's witness statements every time they don't have a dealer's disclosure document. So your lordship is right. What happens in these cases, and one sees it on both sides, is quite a lot of cut and pasted evidence. I know a point Mr. Wilson makes as well. So your lordship is I think that's a fair observation if one were to have a bespoke piece of evidence about each case. So what I had flagged that I was proposing to do next, just before looking carefully at the suitability document, was to show the court the evidence in both cases as to what Mr. Johnson and Mr. Wrench each said about the nature of the finance that they were offered. And if I could start, please, with Mr. Johnson's evidence. I'll take this briefly as I can. It's at page 4 of the supplemental bundle. Supplemental bundle, Johnson, page 4. And it starts at paragraph 7, top of page 4, where here's Mr. Johnson. I recall I had a brief look online when I was able to arrange a finance quote from a lender and book an appointment with my closest dealership. 8, I can't recall which finance company the quote was from, but it was not from Motonovo. 9, on arriving at the dealership, I was met at the door by some sales representative who showed me around a few cars. 10, I'd learned to drive in a Ford Fiesta, so I was initially looking for one of those. I was keen to get a fairly new car that wouldn't cause me any problems. Skipping to 11, missing some irrelevant words. The Fiesta proved a little small. I also tried a Volkswagen. 12, I was eventually shown a Suzuki Swift, which I found to my liking. Took it for a test drive. 13, I remember one of the sales representatives making a comment he couldn't believe how good a deal I was getting. 14, unfortunately, I was then advised that the finance that arranged would not be sufficient for the Suzuki. 15, instead I was offered a finance agreement spread over 5 years, although the monthly payments were the same as my quote, but unfortunately that wasn't accepted. And finally, 16, I then spoke to a different person and was accepted for an agreement with a higher monthly payment. I was not offered any finance offers. So the impression in this witness statement is that in addition to the online quote that he gets at paragraph 7, that there were 2 finance offers, paragraphs 15 and 16, one that was not accepted, 2 finance offers from Firstrand, one that was not accepted, the second of which was accepted. So if one can just see briefly the cross-examination on this, and this jumping down to page 65, so into tab 19, page 65. I'm going to start at the top of page 66 to save time. So top of page 66, this is Ian MacDonald of Council cross-examining Mr. Johnson, top of page 66 in the supplemental bundle. Mr. MacDonald of Council picks up this point that I refer. He says, reading from the top, I mean, the way you've put that at para 14 is it wouldn't be sufficient, not that they wanted to give you a different finance agreement, but that it would not be sufficient. And then the answer, Mr. Johnson, yes, I remember a lady at a computer saying it just wouldn't work for some reason, then proceeded to set me up with somebody else. Question, is this the agreement you're talking about at para 15? Answer, yes. Then you go on to say, but unfortunately this wasn't accepted. So does that mean your credit application was turned down? Mr. Johnson, I'm sorry, but I'm a bit mixed up now. I'm not really sure. Mr. MacDonald, take your time. I'm looking at paragraph 15. I'm trying to run through the chronology. And question. And then we're at para 15, where you say you're offered presumably a different finance agreement spread over 5 years, but unfortunately that wasn't accepted. My question is to you, does that mean you made a credit application that was refused at that point? Mr. Johnson, no. I think that's referring to the quote I went into the dealership with beforehand. That's what, and then Judge Sandercock, well, there must have been another one, Mr. Johnson. Must there not? Because you arranged something yourself, and then at para 15 you say you were told that that wouldn't work out, and then you were offered a different agreement. That's para 15. So there are at least 2 suggestions you had for how you might finance this. Mr. Johnson, yes, I see. I think the monthly payments I went in there with from the quote I received online. I think what I mean is that that was not accepted. So they offered me a different agreement. Question, yes, but then you say, unfortunately, that was not accepted. Mr. Johnson, yes, I see, but I'm not sure what I was even referring to. Sorry. So it's less than clear, the evidence, but the upshot appears to be that only a single product was suggested by the trade centre a single product. The product that was turned down, as it were, or not acceptable, was the online product Mr. Johnson had gone into the dealership. And that certainly is how it's understood and interpreted by the judge, District Judge Sandercock. And if you'd kindly go to the paragraph in the judgment, this is core bundle 203, paragraph 10. So we're looking core bundle, divider 14, page 203. Yes, so picking up at page 203, about halfway down the page, Deputy District Judge Sandercock at paragraph 10 says he was offered, so that's Mr. Johnson was offered an agreement for a total amount of 6,399 at a flat rate of 8%. So just one offer. And then if you look at the...
Well, it's paragraph 7 deals with the rather muddled
yes,
that we just gone through.
Thank you.
Several other staff spoke to him about finance before a salesman offered the agreement on the 29th of July.
Yes, indeed. I think the only other paragraph that I had in mind to refer the court to in relation to this was paragraph 53 at the top of page 211, which is important for another reason as well, but it's the top of page 211. This is paragraph 53 of the judgment, where the Deputy District Judge says one can go further from his responses to questions, especially regarding the documentation. I find the claimant didn't rely on the salesman broker for information. I find he didn't care whether to inquire at all. For all that he was relatively unsophisticated financially, he was aware of the general level of rates and amounts and period of instalments. He had already made an arrangement of his own by himself. He was able to appraise the value of the contract he was being offered. So again, it's the single offer. It was not a difficult transaction for him to understand. So we've written in our skeleton, the evidence appears to be accepted that a single product was suggested to Mr. Johnson by the trade centre. The decision, we say, was for him whether or not to accept that product. I want to next then come to the suitability document. And it is, of course, at tab 11 of Johnson Suitability Supplemental Bundle, page 37. And it's the only observation on the front page of page 37 that is in the middle of the page, particularly your Lordship, Lord Justice Edis will see right in the middle a date and a time, 29th of July, 1511. There is a time on a proposal document, which is at tab 9, which is at about 2:30. It's at, oh sorry, well if you look at 35, page 35 of the same bundle in the finance proposal form. Difficult to read, but top right, very top right, date time. So looking at page 35 of the same bundle, this is finance proposal. And one can see date time, same day, 29th of July, but 1433.
Yeah.
So that looks like the first document that's completed by the dealer with Mr. Johnson. So the suitability document is produced some 40 minutes later in the process.
Is this all being done online then?
That is my understanding, that it is an online process. Having said which, your ladyship will have noticed that the document at 35 has a signature.
Well, that's the reason I queried it, because I think 37's got a signature as well.
It does indeed.
Not an electronic one. It may well be that they're printed off and signed.
Yes. So back to 37, if I might, that 29th of July suitability document. And the court has seen page 38 now, obviously a couple of times. And looking in the middle we will undertake, sorry, it's about a third of the way down, 38, isn't it? We will undertake an assessment of your demands and needs for consumer finance and provide an illustration of the consumer finance product that best meets your individual requirements based on the answers you provide. And just pausing there, plainly Mr. Johnson was an individual who needed consumer finance with which to buy a car. He'd already reached that conclusion before stepping foot inside the dealership because he had done his own online investigation to arrange a finance quote. And of course, we know he thought when he arrived he might want a Ford Fiesta, but he prefers the larger Suzuki. That has a price of £6,499, but he only has a £100 deposit. So certainly he is an individual who needs a consumer finance product, in the words of this document. Now, you have seen the panel of lenders that then follows, and it's the 11th lender on page 39 that is Firstrand Bank Limited. Let me just pick up there. We don't know what the other lenders, the identity of the other lenders, because of the redacted form of the document. As I mentioned, we did try to get the unredacted form of it last week, but were unsuccessful. I should also say, and more substantively, because this document was not explored at trial, there was no examination as to why it might be in the dealer's commercial interests to have a wide panel of lenders. But I respectfully submit that the point is straightforward. Dealers are trying to sell cars, and finance enables them to do that. And a wider panel of lenders enables them to offer solutions to a wider and more diverse customer base. And I don't need to tell your ladyship that lenders operate in different markets: prime, near prime, subprime. And different lenders in different markets have different lending criteria. Point, in fact, that Mr. Irving says, but doesn't explain at paragraph 26 of his statement. I should also say, my lady, that in the motor finance market, I am instructed that some lenders will not take on people with, for example, provisional driving licenses, or taxi drivers, or the self-employed, or new drivers, or those with low deposits, or those on benefits. Some lenders might only offer hire purchase as opposed to unsecured loans. So, without labouring it any further, the wider the lender panel, the better the chance that the motor dealer can secure a finance option for a customer, thus securing the sale that it's in the interest of the dealer to secure.
And providing the customer with the service that the customer wants, because the customer wants to buy the car and the dealer wants to sell it. So they both have a communal interest in getting the sale facilitated, don't they?
Can I explore the sort of alignment point? I was going to deal with that a little bit later, if I might, my lady, when looking at both functions. But it's a very important point, and I'm grateful for your ladyship raising it. If I could just, though, complete the sort of analysis of the document, because after the last redaction, we get consumer finance demands and needs assessment in this bubble. And we're told the following pages provide a record of the responses given by you during the assessment of your demands and needs for consumer finance. The answers provided have been used to generate the following illustration of the consumer finance product that best meets your individual requirements. If you then turn over page to 40, you see a decision tree, which might just be the shortest decision tree that one has seen. About you, are you a private buyer or business user? First question. Answer, private. Question 2, what is the age of the vehicle you are purchasing? Used, more than 3 years old. So that's the decision tree. That's it. Just those two questions and those two simple answers. He's a private buyer of a 3-year-old plus second-hand car. Now that's the decision tree done, and one moves to the assessment of suitability, and you see that under the heading Suitability. 1. Given your requirements and responses, the ones above, to the specific questions on finance, the finance option which appears to be most suited to your requirements is hire purchase conditional sale. And my understanding is the difference between conditional sale, there's no optionality at the end of the agreement as to purchase. Hire purchase, there is an optionality element. But the finance option identified then as the most suited is hire purchase / consumer sale. And again, that assessment appears to have been a very straightforward one in relation to an individual who wants a car for £6,500, only has a £100 deposit. That is the obvious finance option. But when then comes to point 2, which finance company has been selected to provide funds? The bubble Firstrand Bank Limited. And then 3 follow-up points. Please indicate the reason why this particular company has been selected. Lender offered acceptance to match terms required by customer. Tick here to record this has been confirmed with the customer. Tick. In arriving at this finance company, have any alternative providers declined a proposal? No. So, just...
Doesn't quite chime with the evidence, does it?
Well, it says what it says.
Yeah.
And
the evidence is a bit muddled. Yeah.
What I would respectfully submit is the Trade Centre Wales has stated that the finance option most suited, I'm being obviously very careful to record exact words, was the hire purchase conditional sale finance option. When it comes to the selected finance company, the document simply states that Firstrand has been selected and the reason given because the lender offered acceptance to match the terms required by the customer, the box ticked to that effect, and then a confirmation that no other alternative providers have declined a proposal. And the reason that I look at this carefully with respect is that there's nothing in this document that makes any sort of comparative statement. There's nothing in which the bank offered the best deal, or the cheapest deal, or the most competitive deal. Again,
despite the fact that it says it's the financial product that best meets your individual clients, that they're saying that they're taking on advice, again, this is an illustration of the consumer finance that best meets your individual requirements.
Well, again, it is quite clear that the most suited finance option is stated to be hire purchase. I absolutely accept that. But in relation to the selection, and I'll come to that in more detail in a moment as to Firstrand, nothing of a comparative nature is said. And you'll recollect that Mr. Weir took you in the McWilliam case to the very clear evidence. I called her Mrs. Wilson yesterday, and that was wrong. She was called Mrs. Gregory. But Mrs. Gregory of Norton gives quite clear evidence that from the panel, the lender would be, the option would be the one with the most competitive interest rate. And it's on the back of that that the judge, on those facts, finds the duty that he finds. But this is back to the observation, of course, of Lady Justice Aspin in Conway and Ease, that this is an area where the facts are so important, that these findings are so sensitive to the facts. I respectfully submit, the last time I'll say it, that there is nothing in this document that suggests any sort of comparative lender selection, anything about best deal, the cheapest deal, or competitive.
Well,
and when one then
Mr.
comes...
Hardwick, could we
Of course.
just look at page 38?
Of course.
And just have your submission about what the paragraph beginning, we will undertake an assessment of your demands and needs. What does that paragraph mean?
Well, I'm grateful. Demands and needs for consumer finance and an illustration of the consumer finance product.
I've highlighted the word best.
Yes, and respectfully, that is absolutely what is then said under the suitability section at 40. The best or the most suited, so the words most suited there appear under the suitability head. The most suited finance option is hire purchase. Not something else, not a credit card or a loan or a personal agreement, a hire purchase. That's the finance option, which, as I say, is a rather straightforward assessment, one might think. But when one is looking for a statement as to, we'll give you the best lender, the best interest rate, the cheapest, that's not what was said to either Mr. Johnson or Mr. Wrench, and it was not what was said in this document. That's my.
It's not how the man in the street would understand it. It's a very clever way in which a lawyer would put it, Mr. Hardwick.
Well, I am going to, my lady, show you again what Mr. Johnson and Mr. Wrench's evidence was about
Yes.
the quote best deal. But that is my submission on the document. When you look at it rather carefully, that interestingly, the reason for the selection is, well, the lender offered acceptance to match the terms. Has anyone else been declined? No. Not a single one of that panel of 20. No one else has said no. So nothing comparative, respectfully. And then when you look at the finance terms, and this is so important in the context of the vulnerability complaint, which I'll develop later. But if you look at the top of 40, and look at the finance terms, you've got the initial payment, 153, the monthly payments, 153. You've got the charge for credit, 8%. That's the fourth black bubble on page 41. And then halfway down the page, given the level of finance, you happy you'll be able to afford to make repayments, bubble, yes. So the finance information is absolutely clear in this document. Now, of course, it's signed by Mr. Johnson, not referred to at trial, but there are 3 other documents which were all provided to Mr. Johnson in the pack of information, which I'll be looking at shortly, but just so that the court knows, the 3 documents, the pre-contractual explanations at tab 6, the pre-contract credit information at tab 8, and the unexecuted hire purchase agreement, tab 7. So there are 3 other documents which set out these very clear finance terms. It'll be £153.72 per month. The interest rate is 8%. Nothing in those documents either to the effect that these terms are the cheapest, most competitive, or the best deal.
So when there's a reference to a finance option in this document, is that simply hire purchase?
Yes, respectfully, that's what and one can see it from that suitability, those 3 short sentences underneath suitability. Given your requirements.
Look at 43, middle of 43. Based on our discussions and our responses to our questions, we will have narrowed down the selection of finance options to the one that may be most appropriate, given your personal circumstances and requirements. You're just simply saying to somebody, well, HP or conditional sale is the most suitable, doesn't make a great deal of sense, does it?
Well, we know the question.
Could take out a personal loan. Could.
Again, the key.
Yeah, loan approval process. Look at page 42. Your dealer will assist with calculating the amount of finance required to complete your vehicle purchase, etc., etc. As part of the loan approval process, personal details for each applicant will be passed to one or more finance companies. And
all of which we accept, my lady.
Yeah.
Is this man the one who took out a hire purchase agreement and a personal loan?
Yes, that's absolutely correct, because the car was above the glass guide.
Yes.
The 4,600 odd. There needed to be a personal loan on top of that, 1,500. That's absolutely right.
That doesn't make a lot of sense, does it, when you look at the top of page 40, which says the most suitable finance option is hire purchase conditional sale. Actually, it was hire purchase conditional sale and an additional personal loan was being offered.
Your Lordship, I obviously accept that. It doesn't feature in this what appears to be a sort of bespoke document which deals with the hire purchase aspect, not the personal loan agreement aspect. I accept that, obviously. But every reference to finance option product, I respectfully submit, is to that product of hire purchase, which is assessed on the back of the 2 questions. The decision tree is there, just the very 2 simple questions, the 2 simple answers. Your best finance option, your most suited, is hire purchase. The selection of the lender, well, as I've said, it's Firstrand. No one else has declined finance. It's not, in my respectful submission, a complicated half page, that at the top of page 40. if it's read, it means what it said. There's one lender has stepped up, no one else has said no. But in terms of any element of the document that is promising or suggesting this is the best deal, of these 22 lenders, this is the best one, the most competitive interest rates, I respectfully submit it's not there, and it's not impliedly there either. And if I could then take the court back to the evidence of Mr. Johnson and Mr. Wrench, we're obviously in a strange world looking at this document because it wasn't relied on at all below, although of course I accepted the sign. I should perhaps just in pausing while I say that, we've never quite understood why it's accepted that Johnson is a half-secret case, but that Wrench isn't. And yes, I think in day one, Mr. Weir explained that Mr. Johnson signed this document, which is of course the document that contains the may pay commission. And that's the first time I've understood that it appears to be Mr. Johnson's signing of the document, which makes this a half-secret case, which, without wanting to switch issues, dovetails very much with my submissions on why Wrench is a half-secret case. But let me not get off track. If I can come back then to the evidence of Mr. Johnson and Mr. Wrench as to whether they were offered the best deal or whether any of that ilk was said to them. Can I start with the Johnson evidence? And the straightforward point, and we've just looked at it, is the absence of any suggestion that the Firstrand's proposal was the best deal or the most competitive deal. We've looked at the short passages in his witness statement. Paragraph 16 is the one we read. I'll read it again. I spoke to a different person, was accepted for an agreement with a higher monthly payment. I was not offered any other finance offers. So there's no reference by Mr. Johnson to a suitability document. There's no reference to a panel of lenders. No evidence that the trade centre stated or suggested that this is the best deal, Mr. Johnson. There's just nothing of that ilk. And we've looked again at the findings of Deputy District Judge Sandercock. I referred the court to that paragraph 53, where his finding was the claimant didn't rely on the salesman or broker for information. So that's really Mr. Johnson. That's very straightforward. Mr. Wrench, you'll recollect, it's relied on heavily that he, in his witness statement, well, the claim is made 19 of the appellant skeleton argument and 118, that Mr. Wrench was orally told by the brokers that they would get him the best rate. And that's, you've heard that submission from Mr. Weir. One has to be a bit careful with that. And can I just start in Wrench with his pleaded case as to the best rate point? And that is at core bundle, tab 28, page 344. So this is core bundle, tab 28, page 344, under the heading, the circumstances of sale. So Mr. Wrench's particulars of claim, 24th of October 2022, and he says at 25, well, his pleading says, the claimant averred it was his first time using the said credit broker when he obtained his first credit agreement. During the said agreements, the credit broker did not inform the claimant that the offer made by the defendant was a good deal or low-cost repayments, and neither did they explain the terms of the agreements clearly to him prior to signing the said agreements. Then 27, claimant averred that he was only told that his finance agreements were through with the defendant. The credit broker did not tell him about any information with respect to commission and or whether his application was submitted to a panel of lenders or considering offering finance of the loan. So this is the pleaded case of Mr. Wrench. And unequivocally, his pleaded case is that the credit broker, and remember he's got two credit brokers, First Lane Motors in the first team, Prestige in the second, didn't inform him that the offer made by the lender was a good deal or low-cost repayments. and didn't tell him that his application was submitted to a panel of lenders. So again, without labouring it too much, not only is there no claim that the broker stated that he'd be given the best rate, he's actually gone positively further than that, Mr. Wrench, and said neither broker said anything about whether the deal was a good deal or a low-cost deal. So that's
the reference to the credit broker, a reference to both.
Both of them. Yeah, that's right. They're both defined as credit brokers with capital C, capital B, up at paragraphs 2 and 3. So it's Fast Lane Motors and TT Prestige. One of the features of the evidence and pleading that there's really no sort of identikit evidence is given for both. So that's the pleaded case. If you then go to the witness statement claim, which is centrally relied upon by the appellants, that is back, I'm afraid, into the Wrench supplemental bundle, page 4. And you have been shown paras 12, 13 and 14 is worth revisiting in the light of what we've just seen pleaded. If you look at 12, so to be clear again, this is the Wrench witness statement. Para 12, the dealer didn't tell me how the finance worked in any great detail, didn't request or get told what type of finance I would need, and the salesperson chose the most appropriate way for me to purchase. On each occasion, I was told the dealership would find me the best rate from their panel of lenders. And 13, I was told a credit check was going to be carried out, but I didn't get shown the credit check. 14, after the check, I was not offered a panel of lenders, and I was not aware of the fact that other financial lenders were an option. So just pausing there, it's rather curious evidence, because the two credit agreements were 22 months apart. 23rd of May 2015 and the 11th of March 2017. 22 months apart, different credit brokers. But he makes an identical claim in respect of each of them, that on each occasion he was told by someone unidentified that the dealership would find me the best deal from their panel of lenders. Well then, apparently then, after the credit check, he was not offered a panel and he was not aware that other lenders were an option. Well, that was then the subject of some cross-examination. If I could ask the court please to go to page 113. Again, I'm going to take this as quickly as I can. I don't want to waste time. Let me actually start at 1110. I apologise. I should start at 1110. So this is now in the Mr. Moody's cross-examination. Mr. Moody of counsel is cross-examining Mr. Wrench in the trial on the 12th of June 2023. And it starts at 1:10. Question, once you saw the Audi TT, you wanted the Audi TT, is that right? Mr. Wrench says, yes, the TT is a little more sensitive than what it gives. I was walking past the time with one of my dogs. My mother-in-law had just died a week before, and at that time, she always had mentioned saying I'd love a TT, and fun enough, it was just there, stared at me. I took a picture, went home and showed it to her. Even then, still the remorse within a week, I was excited for her seeing that, even though she said, yes, I want this car, I'd like it. I went back within 24 hours to buy it for her. Yes, but that's not relevant, that's just me at the time. I saw it online, I saw the pictures. Question, so going to the Audi TT, after you chose the car, your wife was excited, you then thought how best to buy the car. And I'm not going to go 111, that's a bit of a discussion about the affordability, but 1112 to the bottom, you'll see the last two lines of 1112. Mr. Wrench saying, I could have lost the car if I hadn't acted immediately at that particular time. At the time, the opportunity did not arise for me just to say, bank or other companies. Very busy person within my job at the time. Given the circumstances, they were local. Question from counsel, at risk of losing the car, you decided not to shop around. You took out the finance that was offered to you there. This should not be a particularly controversial question. You decided not to shop around. Answer, I think in hindsight, sorry, not in hindsight, there's an interruption. And then answer at line 15. For clarification, I will do that. I walk in the dealership, I see the car, I sit down, and they literally then move towards their finance company, which is one and one only, which was Motonovo. How about we do this? What deposit can you afford? We go through the ramifications. I decide the budget was doable, the deposit was doable, the transaction took place, they were happy, they then get it validated. I picked it up or it was delivered a week later. So that's the TT, the Audi TT, the purchase and the finance transaction in 2050. Very briefly, in relation to the second credit agreement for the BMW, page 1141, short passage, 114, line 8. Question. My question is, after a number of years of paying for the Audi TT, the finance is completed, you went to buy the BMW, whoever it was, for, and the same as what happened with the Audi TT, you were offered some finance on the table in front of you, and you chose to take out that finance. Answer, which was Motonovo again, which was the element of trust. Yes. And sorry, there is one final passage at 124. That really is it. 124. Line 50, where Mr. Wrench reads his evidence. He's been questioned about his evidence. And he says, I'll read it verbatim. At this time, this is my statement. After the check, the credit check, they go upstairs to do the credit checks, come back with the documentation and say, right, that's great, everything's fine. The documentation is on the table. And at no point was I not offered, looks like a double negative, panel of lenders, and I was not aware of the fact that any other financial lenders were an option. So again, in the course of this cross-examination, in relation to the circumstances of each sale, Mr. Wrench did not say a word about being told that the dealership would find me the best rate from their panel of lenders.
He wasn't cross-examined about it.
My lady,
There's not a word in this cross-examination passage that challenges that evidence. He volunteers evidence as to what happened in answer to different questions, but he's not cross-examined on that point at all.
My lady, I accept that there was no direct question on that.
No.
But
so that's his evidence and it's unchallenged.
But I do respectfully submit that the evidence we see here is consistent with his pleaded case, which we've just looked at, that he was not told that the finance was a good deal or a low cost repayments. And just to pick up your ladyship's point, which certainly was an observation Mr. Weir made, if I can just look at the oral closing on this with a little bit more detail. It's 202 of the same bundle. 202 of the same bundle at line 19. So we're now in the closing oral submissions of Mr. Lawton of counsel for Mr. Wrench, beginning at line 19, and Mr. Lawton for Mr. Wrench. So this is line 19 of page 202, oral closing submissions. Line 19. If I could take you, please, to page 84 of the trial bundle, sir. Looking at paragraph 12, the dealer didn't tell me how the finance worked. I did not request to get told what type of finance. Skipping 2 lines. On each occasion, I was told that the dealership would find me the best rate. So counsel reads out that paragraph 12. And then the Deputy District Judge, Harrop, intervenes. These are 2 different dealers, 2 years apart. Mr. Lawson, yes, sir. The Deputy District Judge says the claimant's evidence is they both said exactly that thing. That is his evidence, is it not? And then Mr. Lawton says, that's as I understand it, sir. I don't think there was any cross-examination to the contrary in that regard. But yes, that is, as I understand, his evidence. My lady is right about the cross-examination submission. Equally, the court will observe the district judge's interventions, making the observation really I've just made, that this is identical evidence of best deal in relation to 2 credit agreements 22 months apart. When you come then to the judgment of Deputy District Judge Harrop, I probably should look at that finally to end the circle. And it's at page 315 of the core bundle. 315. So this is Deputy District Judge Harrop. 315, paragraph 21. what he says, the judge's conclusion here, Mr. Weir, we did look at it with Mr. Weir. The claimant's evidence is, in summary, that in the case of both agreements, he was given very little information by word of mouth, that he was asked to make a number of signatures upon documents, that he trusted the broker. I accepted his evidence on that issue. So the judge essentially accepts the perfunctory nature of the exchanges that we saw as described by Mr. Wrench. But clearly there was no finding that the dealers had declared that they would find, in respect of each credit agreement, the best rate from their panel of lenders.
Well, there's no express finding, but he says the only information about the dealings is that provided by the claimant in his evidence, both in his statement and by word of mouth. There's no finding that he disbelieved him on any part of his statement. He wasn't cross-examined about it, therefore the evidence was unchallenged. I am simply wondering, on the basis of that, what wriggle room there would ever be for a making of a finding of fact that contradicted it, if it were to go back for a further hearing.
My lady, as ever, perhaps this is the penumbra of indecision to which Lord Hoffman refers on appeals. But when the judge is referring to the very little information by word of mouth, I respectfully submit that what the judge has in mind was that evidence from Mr. Wrench when he cuts to the chase and says, look, I went into the dealership, I sit down, they move towards the finance, which is one only, which is Motonovo. I mean, that really was the core evidence that Mr. Wrench gives under cross-examination. How about this? What deposit? We go through the ramifications. Very perfunctory exchanges. And that's, respectfully, is what this district judge is referring to when he says the very little information by word of mouth. It is clear that in relation to the so-called best deal evidence, those interjections in the closing submissions suggest some surprise that identical evidence is given in relation to credit agreements 22 months ago.
I suppose that might be surprising, though, if on neither of those occasions there had been no discussion at all about what the rate was going to be, which is what the answers in cross-examination would suggest. That would be quite surprising too, wouldn't it?
The rate?
Yes. You'd expect him to be interested in the rate he was going to be charged.
I mean, just to be clear, the dealer disclosed the first document.
No, I'm talking about his oral evidence in cross-examination, where I don't think he says anything about any discussion about the rate of interest, does he?
No, I don't.
But there must have been some discussion about the rate of interest, surely, on at least one of those two occasions.
What one knows from the proposal form that we looked at 1429, that proposal form, is that, let me just get it up if I might, as an indication. I think it's actually, it's probably, it's in Johnson, so it's not going to help, but it's a page 35 of the supplemental bundle in Johnson. It does, that finance proposal form has an interest rate in it and a monthly payment. It's actually not the same.
He knew what the monthly payments were because part of his evidence in cross-examination refers to, I knew it was affordable.
Yes,
Can I come then to the key arguments, having surveyed the evidence, the fiduciary duty arguments? And the first argument we detect, looking at paragraph 19 of their skeleton, is the assertion that given each broker knew the financial deals on offer from its panel, they were each duty-bound to inform the claimant of the most competitive or the best deal. Respectfully, the assertion that there was a broker duty to inform the claimant of the most competitive or the best deal is wrong. No such duty was assumed by the Trade Centre Wales in the suitability document. No such duty arises out of any identified contract. No such duty arises out of any regulatory provision. And in relation to the suggestion that the best deal duty is precisely the evidence of Mr. Wrench, you have the submissions I've just made in relation to the opposite plea, in fact, to paragraph 25 of this particular plea. So the second way it's put is that one should apply from the imply from the function that the brokers undertook to obtain a competitive or the best deal. It's an implication argument developed particularly at 117 and 118 of the appellant's skeleton argument, also 34 and 35 of the supplemental one. We've looked now carefully at the function the broker was exercising with reference to the Article 36A definition of credit broking, the evidence of Miss Shaw of Hopcraft, who went through the standard process, looked at the Johnson suitability document, and looked at the evidence in each of Wrench and Johnson. And respectfully, I submit that it is clear that the brokers, Fastlane, TT Prestige, Trade Centre Wales, were effecting an introduction of the individuals to the bank with a view to the bank entering into, by way of business as lender, a regulated credit agreement. They were gathering information about the claimants, uploading that information to an electronic platform, liaising with the claimants in relation to the lender offer, but they were not undertaking to obtain a competitive or the best deal from the range available. They didn't say that, and they didn't imply that. Now, one of the arguments deployed by Mr. Weir is, well, look at the cases. Look at Herstanger, McWilliam, and Medstead. Two responses to that. First, I've already prayed in aid, Lady Justice Aspling's observation, Conway and Ease, paragraph 38. The inquiry into the nature and extent of the fiduciary duties owed is extremely fact-sensitive, with reference to Lord Upjohn in Boardman and Phipps, in turn referencing Reed Coomer and a paragraph in Bousted and Agency. It's absolutely critical, the extreme fact sensitivity in each case in relation to the proper inquiry. And so that comes to the second point. The problem with those cases is the facts of them are fundamentally different to the facts in Wrench, Johnson and Hopcraft. No prior dealings between the claimants and the brokers. No fees paid at all. The court will know that Mrs. Wood paid £18,000 to her broker in the Wood case. Mr. Wilson paid £1,000 to Mr. Dunk in her stay. No fees paid. Thirdly, no contract specifying the functions performed. Again, by contrast with Wood, paragraph 16, with Herstanger, paragraph 4. Particular reliance was placed upon McWilliam, and I've already again reminded the court that there was direct evidence from Mrs. Gregory that the applicant is told of the loan with the most competitive interest rate. These are different cases with different facts, and they fundamentally affect the inquiry as to the existence of a fiduciary duty. Can I then come, though, to the absolutely critical feature of these motor deal cases, which so clearly distinguishes them from the independent credit brokers in Herstanger, McWilliam, Medstead and Wood. Now, independent credit brokers, that's not my word. Lord Justice Tomlinson in McWilliam at paragraph 44, that's his term, independent. And it's the right adjective because those credit brokers had a single function to perform, to act on behalf of the customers for a fee and pursuant to a contract, except for Medstead, in selecting the appropriate lender and mortgage product. In these motor dealer cases, the broker motor dealers are primarily interested in the sale of the car purchased by them and sitting on their forecourts. And as we say at para 88 of our skeleton, these are insurmountable obstacles to the fiduciary duty claim because obsessed objectively, the brokers didn't earn a single-minded duty of loyalty to Mr. Wrench and Mr. Johnson. The customers can have had no reasonable expectation of the abnegation of self-interest. The brokers, while motor dealers, were seeking to sell the vehicles and make a profit for themselves. And that creates the plainest of conflicts and is inconsistent with the assumption of a fiduciary duty. Again, to use the words of Lady Arden, in each case the broker was not acting only for the benefit of another, but was at the same time acting for himself. That's CIFF, para 45. Can I then come on the...
If that's the case, it's a matter of proper analysis. It's absolutely curious that your clients should be so keen to make sure that they disclose their commission to the purchasers. They'd have no business disclosing their commission if they were simply totally independent people that were being paid by you. There'd be no secret commission about it. The FCA wouldn't require anything to be said.
My lady, as I explained yesterday, the reality in 2050 were that dealers did have, in certain circumstances where it affected impartiality, an obligation of commission disclosure. And my well-advised clients know that perfectly well. That was a change from the 1st of April 2014. We're dealing with 2050.
But there's got to be a reason for it.
Well, my clients also are aware of Conc 1.2.2, which is often argued by claimants to impose a...
1.2.2 doesn't exist in the ether. That's the point. It's founded on equitable principles. It's founded upon principles that you are dealing with somebody who might be said to owe duties both ways. That's the real problem with your case, it seems to me, is that they're not acting in a single-minded way. They are... anybody standing back and looking at it would say, well, yes, the customer might expect them to get paid from some source or the other. And that's right, because they're not paying them themselves. They're not paying them a fee. That's your distinction between that case and the wood line of authorities. You say, well, different if you're paying your own agent and you don't expect them to be getting paid from the other side of the bargain. You're still, there's still a requirement that they tell you, and there's got to be a reason for that.
My lady, thank you. Number of points raised there, which let me see if I can address. The first is in relation to Conc. And again, respectfully, I submit that in a new regulatory context, where well-advised lenders are aware that dealers with whom they are dealing have got a Conc duty to disclose commission in certain circumstances, twinned with another rule, Conc 1.2.2, that they may have a responsibility to take steps in relation to people acting on their behalf, and that's another rule. Any well-advised lender is going to think, right, we need to ensure that those with whom we deal disclose commission. And that is, respectfully, nothing to do with any existing equitable or common law principles. It's just dealers well-advised, thumbing through the FCA handbook, thinking of other ways they might be under attack from claimants. Now, in relation to the question of the sort of interplay between Conc and equitable and other duties, I would respectfully remind your ladyship of the Philip and Barclays case, which is tab 46 of the additional authorities. I wasn't proposing to go to it.
No.
It's referred to in particular paragraph 70 by the Close Brothers, but it's an interesting analysis in the advanced push payment fraud of the new regulatory landscape which was emerging. And Lord Legate at 22, 23 and 24 makes some very interesting comments about the real difference between the courts and the legislators and regulators, and the very different constitutional, institutional position, the different reasoning, the different principles, the different policies. And it's effectively the two are separate. Mm-hmm. One cannot read from the fact that a Conc rule is passed that it's reflecting an existing common law. One might say exactly the opposite, precisely because there are no duties. The regulator has perceived a need for a rule. Respectfully, those are my submissions on that. But in answering your ladyship's further point, can I take the court to an important decision in this court, Mercantile and Hamden, which is directly relevant to this whole issue? It's at Additional Authorities, tab 16, which is volume 1. I've at last worked out the volume breakdown, and it's at tab 16. And I'm going to cut to the chase because of time. It's a Court of Appeal decision, Service Pearson and Salmon. It was the claim by, so this is tab 16. Just the facts were claimed by a hire purchase company, Mercantile Credit, against Mrs. Hamblin for the return of a car. And Mrs. Hamblin had wanted to and thought she was borrowing £1,000 on the security of the Jaguar car she already owned. But the apparently respectable motor vehicle dealer, Mr. John Phelan, had supplied her with hire purchase proposal forms. She signs them without reading them and suddenly finds herself as a purported hirer of a car, indeed her own car. Well, no, not her own car, a different car. Anyway, look, Mercantile Credit pay Mr. Phelan for the car. Mrs. Hamblin refuses to make payments under the HP instalments she's inadvertently entered into. Mercantile Credit sue for the return of the car. What happens is that the judge at first instance holds that Mrs. Hamblin can rely on a non-est factum defence. And second, in addition, that Mrs. Hamblin was not precluded from denying the motor dealer's authority to sell the car. On the appeal, the non-est factum point is successfully appealed. The Court of Appeal says, no, that doesn't work. Non-est factum doesn't work. So the critical
could have read
issue...
it and didn't.
Sorry?
She could have read it and didn't.
Absolutely. So the critical, the sole issue on the appeal for the successive failure is, does the dealer have the authority of the customer, Mrs. Hamblin, to complete the HP forms to sell the car? And I can jump in with that, I hope coherent explanation of what it was about. So page 328. And here now is Lord Justice Pearson engaging at E, halfway down page 328, with the second point. Non-est factum fails, successfully appealed. There is, however, picking up at E, the second point on which I would agree with the decision of the judge. The defendant only authorised the dealer to make inquiries as to the amount obtainable and to report back to her. He never had actual authority from her to complete the forms or to present them to the finance company. Unless some estoppel operates her against her, the presentation of the forms to the finance company was not her act, and she didn't make any offer. The crucial question is whether, as against the company, she was stopped from denying the dealer's authority to complete the forms. Did she give him ostensible authority? Did she hold him out as the company? So it's all about authority. And over the page, and I see your ladyship is already there, just above B, the judge, after referring to those cases, it seems to me to be a question of fact in each case whether any particular act of the motor dealer was done as a principal or as agent. The B, line 2, there's no rule of law that in a hire purchase agreement the dealer never is or always is acting as agent for the finance company. And here now the passage that we double underline. In a typical hire purchase transaction, the dealer is a party in his own right, selling his car to the finance company, and he's acting primarily on his own benefit and not as general agent for either of the two parties. And we do say that that is this situation. Each of these dealers were in typical hire purchase transactions, and they were acting in their own right, selling cars to the finance company, acting primarily on their own behalf, and not as general agents. Now, there is a critique of our reliance upon this case by the appellants, who say that we are relying on the obiter dicta of the House of Lords in Branwhite. That's 38 of their supplemental skeleton. We have referred to the fact that Lord Morris in Branwhite sets out exactly the same passage, but it's true that the facts of Branwhite were different. But we rely primarily on this, because this issue before the Court of Appeal in Mercantile Credit was squarely about whether the motor dealer, Mr. Phelan, was an agent and was authorised by the hirer, Mrs. Hamblin. And here one has Lord Justice Pearson's explanation. Typical hire purchase transaction, the dealer is a party in his own right.
Well, the issue was whether he was the agent of Mrs. Hamblin for the purpose of binding her
Yes.
to a hire purchase agreement. That's a very different question from the question of whether in this particular scenario the dealer has fiduciary obligations, because nobody's suggesting he's an agent in the true sense of agency.
Look, my lady, I don't pretend that obviously what was being investigated is the same. There is a nuance difference.
You can pray this in aid to reinforce your submission that he's acting in his own selfish interests and owes no duty to anybody else.
Primarily on his
That's
own.
about as far as it goes.
Now, yes, my lady, what is relied upon against us by the appellants is the next paragraph, which beginning just above D, nevertheless, the dealer is to some extent an intermediary between the customer and the finance company, and he may well have, in a particular case, some ad hoc agencies to do particular things on behalf of one or the other, or it may be both of those two parties. So that's relied upon by the appellants. We say, well, hold on, the next line, the example given by Lord Justice Pearson is very important and illuminating. For instance, if the car is delivered by the dealer to the customer after the hire purchase agreement has been concluded, the dealer must be making delivery as agent of the finance company. Now, that somewhat chimes with a question of Lord Justice Birss, Lord Justice Birss on the first day. And we have no difficulty, and one can see in that sort of narrow ad hoc agency on the part of the dealer, although with the finance company, there's no difficulty of that coexisting with the fact that the dealer is acting primarily on his own behalf, because that ad hoc agency not only arises after he's achieved his primary interest of selling.
What about the next one? What about the alternative on the other side of the transaction? The customer may authorise the dealer to complete the forms by filling in the particulars and to present the completed forms to the hire purchase company.
Well,
that's a bit closer, isn't it?
Yes, but obviously I accept there's authority both ways. Of course, that's right, that the customer authorises the dealer to upload the forms to the lender, and equally the lender authorises the dealer to provide the Motonovo forms, the branded forms to the customer. So there are those agencies, those ad hoc agencies, as it were, both ways. But the point we stress is if one can identify a sort of narrow ad hoc agency that doesn't conflict with the primary interest of selling the car, there isn't a difficulty. And we're back to the car sitting on the forecourt that's sold to the finance company but hired to the customer. Of course, it's got to be delivered now by the dealer to the customer as the agent of the finance company. No conflict, no division of loyalty, no problem. But in our case, when you understand that the purpose of the credit broking is to sell the vehicle, there is a conflict between the interests of the broker and the customer, because it's in the broker's interest for the customer to obtain finance, regardless of whether it's in the customer's interest. Can I just develop that? Because one of the points that's being made, and just so it's anchored, it's in the appellant's skeleton argument, paragraph, supplemental one at paragraph 53. They have a full heading about how brokers owe the same duties even though they were selling the cars. And they make a point which we completely accept, that an agent can owe fiduciary duties in respect of some functions and not others. And they refer to the New Zealand and Peace case and other authorities. And again, we completely accept that an agent can owe fiduciary duties in respect of some functions, not others. But it depends upon those functions. And Lord Justice Pearson's example is a simple, readily understandable one. I'm not going to, in view of time, go to the Peace case, the Lord Wilberforce case, relied on in the supplemental authorities. But suffice to say that Lord Wilberforce, in that case, looks at the responsibilities of Mr. Coos and observes that there is the dividing line between him as trusted employee and as his personal interest was loosely defined, and arrives at the conclusion that a person in his position may have, in a fiduciary position, acquired one part and not acquired others. On the facts of that case, there were no difficulties. But back squarely to the facts of these cases, what has been said, para 127 of the appellant's skeleton argument, is that the brokers undertake two distinct roles. They sell the cars and they broker the credit agreements. We have responded and said that is artificial. On any sensible commercial analysis, they're the same transaction. The response that came back in the supplemental appellant's skeleton was, well, they're actually three distinct transactions, and Mr. Weir explained something of that yesterday. We think that's cutting it too technically. They're essentially two, aren't they? There is the sale of the car by the broker to the lender, evidenced by the vendor's warranty, and then secondly, there's the leasing and optional sale of the car on hire purchase.
I think there's three. There's the sale to the lender, there's the HP, and there's the arranging of the finance.
we'd respectfully submit that the leasing and the optional sale under the hire purchase is difficult to put a line between it. It's obviously one document, we'd say one transaction, but I don't want to differ with your ladyship on that.
There's only two contracts, that's for sure.
What I submit is that the commercial reality is of the same transaction of the sale of a car for a price to an individual at a
on finance.
On finance. And that's what the judges understood. I mean, the conclusion of His Honour Judge Jarman KC and Johnson at 19, which we've produced in our skeleton at 91.1, was it's difficult to see how in practice or principle a car dealer could offer single-minded loyalty to a customer when dealing with the finance, but not when selling a car to the same customer, which gives rise to the need for finance. Finance is incidental to the purchase of the car for those who need to borrow. We think, with respect, that is well expressed. But can I answer the answer given by the appellants to this, which is essentially this alignment point? And you will have read the appellant supplemental skeleton at 56, that the broker's interests were entirely aligned with those of the claimants. And that's the platform for the conclusion that the only common sense implication, say the appellants, is the brokers were required to get the best deal. Respectfully, the moment, with some thought, the claim of entire alignment can't work. It's wrong. The broker's interest is in the sale of his cars. Lord Justice Pearson, mercantile, he's acting primarily on his own path, selling his car. And in respect of any particular customer, the dealer's commercial interests are best served by selling the car that yields the highest profit. He's not a financial advisor to the customer. He has no concern to identify the maximum amount that a customer should prudently be spending, or for that matter, the type of car appropriate for the customer. He simply wishes to sell the car that yields the highest profit. And
so it's perfectly all right for him to introduce the customer to a loan shark who is going to charge him exorbitant amounts of interest so that he can get a much higher commission. I mean, let's push it to these extremes.
My lady, can I see if I can answer that? I just wanted to finish the analysis of the impossibility of the two distinct roles, and see if I've answered that when I've done that. I'm not trying to duck the question, but see if I can answer it with the analysis. As I say, the overriding factor that influences and informs the motor dealer's conduct is that from the moment that the customer arrives at the dealership, he wants to make the biggest profit from the most expensive car, or negotiate the price of the car upwards that's sitting on the forecourt. And an important aspect of hire purchase, of course, is that the credit is secured on the car. So the dealer knows in principle that he can sell any car to any customer on hire purchase terms because of the security on the car, whether it's a Volkswagen Up or a BMW. There is, of course, the limiting factor as to whether the customer can afford the monthly payments, which we've seen is an assessment carried out by the lender on these documents. But from the moment then that the customer enters the dealership and engages with the dealer, there is a real potential conflict between the interests of the dealer to maximize profits. So his sales pitch, he's aiming to promote and sell the more expensive car, or a particular car at the highest price. We saw Mr. Johnson was told you got a great deal. That's the sales pitch. But then the interest of the customer may be to confine himself to a more modest purchase, which saves more of the family budget for other outgoings, which may avoid the need to commit to the more expensive BMW compared to the Volkswagen Up. And that comes back to the problem, because by the time the dealer has successfully pitched a particular motor vehicle to the car, the BMW say, the required amount of finance fundamentally depends on the price of that car. And so the attempt to put this bright red line between the two roles in the transactions, it doesn't work, because the finance that's required is a function of the sale price of the car, which the dealer has already in principle secured. And how then can there be a duty of undivided loyalty an abnegation of self-interest, even a disinterested duty, at the point when the dealer switches to his second role of brokering the credit agreement, where the required credit is a consequence of the proposed car sale. Now, a true abnegation of self-interest would surely require the dealer, in his second role as credit broker, to revisit the contemplated car purchase by the customer and to review whether the best interests of the customer really were served in committing to the purchase of the very car that the dealer qua seller has just successfully pitched. And respectfully, I submit that that all illustrates the obvious truth of a potential conflict between these two roles, perhaps more elegantly put by Close Brothers. It lacks reality to suggest that the dealer is both interested and disinterested in the same transaction. And with that analysis, my lady, my lords, there is an argument by the appellants that if there's no implicit undertaking, it's 1-1-1-2-4 of their scale, if there's no implicit undertaking to find a suitable, competitive or best deal, then a broker, and I'm quoting, would be entitled to present a deal at the top end of the borrower's affordability. Yes, absolutely.
So,
the broker
in
is
answer to
entitled
my
to
question about the loan shark, your answer is yes. He could introduce the customer with complete impunity to a loan shark.
Well, provided that he complies with all his regulatory duties, and I'm not here in a position to tell you.
Leaving aside regulatory duties, leaving aside the provisions of the Consumer Rights Act and its predecessors, it's perfectly okay because there's no obligation on him not to do that.
I'm not sure the answer to that is, my lady, because I
it's
suspect
got to be
that
yes
there is...
on your analysis. It has to be yes, Mr. Hardwick.
Well,
I'm afraid it does.
my analysis is simply looking at the reality of what the dealer is doing. It cannot be right to say he has an undivided duty of loyalty to the person that he's trying to sell a car to on the forecourt and then just switches in his credit broker function to an abnegation of self-interest. I'm taking a step, that principal point, that it can't work from whatever factual scenarios one wants to put in place.
And because there's no such undiluted duty of loyalty, therefore, it would be, absent all these regulatory frills and whistles that we have with Conk and so forth, it would be perfectly okay for him to pocket a very substantial amount of the price as a commission, a sales commission from the lender.
Well, I mean, obviously, a broker hasn't been able to do that for the last 10 years.
No, but I've said we'll part the regulations. Just look at it from a common law equity point of view. He's got no duties whatsoever. He's entitled to act in his own selfish interests. His own selfish interests involve making as much money out of the deal as possible. Therefore, it would be perfectly okay, subject to all of these other regulatory requirements, for him to take as big a slice off the top as he can from whichever source he likes.
Well, if I can answer the sort of first element of that, to introduce to any lender, including a loan shark, I think the answer in principle is that is probably the introduction can be to anyone. But of course, what the lender or the loan shark has to do is comply with his own requirements in the Consumer Credit Act. And the terms of the finance will be crystal clear. Just as Mr. Johnson can see that he was paying 8%, 18% APR, just as Mr. Wrench could see he was paying 8.75%. If a Mr. Johnson type person who's already Googled what he can get in terms of interest, comes in, he's introduced to a loan shark and it's 33%, you might think to myself, goodness me, this is not the transaction I would wish to enter into. But, my lady, I'm not aware of any particular provision that prevents the motor dealer in his introductory function introducing the consumer to a good lender or a less good lender. I'm not aware that the selection of the lender is something that is regulated in itself. But respectfully, that doesn't affect, I would say, the analysis of the fiduciary duty, the undivided duty of loyalty. The
But
problem
it can't do. That's the point. I mean, I think you have to grasp that particular nettle.
As I understand it,
Sorry, carry on.
I was going to say, as I understand it, Mr. Hyde, the point I think you're trying to make is when the dealer is selling the car in the first place, he's not under any obligation to sell it at an affordable price. If the person would be bankrupted by buying the car, distasteful though that may be, the car dealer has no obligation to protect the customer from selling them a car that would bankrupt them.
That's right.
Aside, forgetting about credit for a minute, just a sum of money.
That is right, my lord.
And that's the point you're making.
That is the point, because the
As I say,
finances...
distasteful though it may be, you say that's the point. And if
That
that
is the
applies to selling the car, why doesn't it apply when you do the rest?
And the moment that he's got his credit broking supposed fiduciary duty hat on, that finance, whether it's 8,000 or 10,000 or 12,000, is the function of the car that he may have sold at too high a price to the consumer because he's negotiated the price up or suggested the consumer buy a more expensive car that would really suit naturally the best interest of the consumer. So one just, how then does this supposed fiduciary credit broker completely compartmentalise the sales process he's just been involved in? Surely he's got to unwind it and suddenly now as an undivided fiduciary. Well, what are you doing buying the BMW? You earn 12,000 a year. No, but the Volkswagen up. Sure, I mean that gets to the problem here. The finance is a function of the sale, and the sale has been done in the primary self-interests of the dealer, just as Lord Justice Pearson says in the typical hire purchase agreement is the case in the mercantile credit. And that's the real problem.
Let's just one more aspect of this. I think we understand the point, and I don't want to cut too much into your time, Mr. Harvick. But taking up my lord's point, no obligation to sell at an affordable price. Of course, there isn't. But if it's the interest of the car dealer to sell the car, and he wants to sell it, there is absolutely no point in his arranging finance or pitching the price at a level which he knows, on the basis of the information he's got, that the customer can't afford. Because if he's got information about the finances and he realises that the finance company is not going to accept that particular quote, then it's a lose-lose situation, isn't it?
My lady's absolutely right, and perhaps that required a nuance, and I gave too readily a complete yes to my Lord Justice Birss. I did say that there was one limiting factor, which is the monthly payments. Subject to that, the dealer knows he can sell any car, the BMW, the Volkswagen up, because it's secured on the HP. Yeah. So he can certainly sell it, perhaps for an imprudent car for an imprudent price. But your ladyship is absolutely right that is subject to the affordability, and that the dealer will know on the dealer form, and in fact, I think it's the Johnson dealer form. It's £149 per month was the contemplated monthly sum. It comes back at £153, but certainly the dealer is aware of the sort of monthly payments. But subject only to that, the dealer can pitch the bigger car, the more expensive car, irrespective of the interests of Mr. Johnson and his family finances. But then, when he switches to his alleged fiduciary role as credit broker, it hasn't been signed this yet, of course. The HP agreement is unexecuted. No one signed anything. Motonovo Finance is uncommitted until the end of the process. Why wouldn't a fiduciary credit broker unlock that sale, that imprudent sale? And I don't want to labour the point anymore. Your court has it. Can I just, and I'm very nearly finished, and I'm very aware I'm cutting across the time of my others, but it's been important to make these points. A lot of play has been made by the appellants in relation to the inequality, vulnerability, asymmetry of the alleged relationships. And that's obviously paragraphs 20 of the appellant's skeleton argument, 124, 125. Can I just be clear what we say about that? Because of course it's right. the claimants don't have access to the lenders on the broker's plan. But we don't accept that that renders them vulnerable in the way of, and we do say that the financial information in relation to the proposed hire purchase agreements in each of Wrench and Johnson was very clear and very comprehensive. It's set out in 3 documents comprising the financial documentation provided by the bank in the loan pack in each case. I've taken you, in Wrench, there are just 2 documents I haven't taken you yet. I have taken you to the first, the pre-contractual explanations at tab 5. But if I could just remind the court, in the Wrench bundle at tab 6, tab 6, page 36, so with a supplemental bundle in Wrench. And this is the pre-contract credit information document. You'll see at 36. You see, if you look at the little number at the bottom right, it's number 2 in the pack of documents. It's a statutorily required document under the CCA, section 55. And you'll see that it sets out the total amount of credit, £5,000. It sets out the amount of payments halfway down the page, £175. It sets out the interest 3/4 of the way down, £2,213. And then over the page, top of page 37, you have costs of the credit, 8.75% interest, and annual percentage rate, 19.3%. So that is that very important statutorily required pre-contract credit information documents. And if I can also just ask you to look at the 3rd of the triumvirate of documents with all this, the same information. It's at tab 7. And that, as I indicated yesterday, there are 2 versions of the unexecuted credit agreement that go in the pack, one for signature, one not. This is actually it's 7 of the pack. This is the unexecuted version, but you have the same critical information as to the amount of the credit a 3rd way down, halfway down the page, the fixed rate of interest, 8.75%, 2/3 of the way down, the annual percentage rate of 19.3%. And so these are really very detailed and very clear as to the nature of the proposed transaction prior to signature. And if any aspect of the finance option was not to Mr. Wrench's liking, which might well be the answer to my lady's shark example, any part of it wasn't to Mr. Wrench's liking, he was free to decline it, to go elsewhere. Actually, his evidence at trial, I'm not going to go to it, but was that he confirmed to the Deputy District Judge he didn't feel any dissatisfaction about the financial terms of the first agreement, that's page 100 of the supplemental bond, and similar evidence in relation to the second agreement. You're happy with it, I duly paid them, absolutely no issues. I'm not going to go to the Johnson documents.
Sorry, wondering, looking for a place when my learned friend's going to pause. He's not pausing at the moment.
About 5 minutes.
Just saying that we've heard a lot about the broker's self-interest. Can I just indicate my self-interest in having 45 minutes to reply?
Yes.
The learned friend for Close Brothers has not started. Mr. Hardwick indicated to be an hour and 20 minutes. As I understand it, he hasn't even started upon accessory liability, and he hasn't had his learned junior tackle the issue of unfair relationships.
Yes.
Mr. Wilson will want the time he wants, but I'm terribly keen to ensure I have 45 minutes at the end, please. And I'm only stopping the flow because he said in such flow, I fear if I don't stop it, it won't be stopped.
My lord, I understand that. Mr. Weir
Partly our fault, Mr.
Well, I'm not going to... Mr. Weir had 5.5 hours. I think I'm about 4 hours and 10 minutes in. I'm sorry. I am taking slightly longer than I thought. I've got 4 pages left. I'm getting there. I'm content with what anyone else would like, but I personally suggest that I keep going and try to...
Yeah, I think you better keep going and we'll stop asking you too many questions, or I will certainly.
I found them very helpful, my lady. I might indicate. So look, the very similar documents in Johnson were provided, and so what I say is there's absolute transparency and clarity in relation to the financial information. Now, the real complaint in relation to vulnerability and asymmetry is that it said, 121 of the appellant's skeleton argument, that this would mean, if the courts below are right, that the broker can, if he sources two deals, has no duty to put forward the more favourable proposal, and indeed might even engineer less suitable proposals. Let me just deal with the more favourable proposal first. The answer to that is back in Wood. I'm not going to go back to it because the court knows it very well. But the references are at paragraphs 110 to 130, where Lord Justice David Richards looks very carefully at the terms and conditions. And 111 of those terms and conditions is we work from a panel of lenders to enable you to select the appropriate lender and the appropriate product to meet your individual circumstances. So there's an express reference to we select the appropriate lender. There are also references to advice and to recommendations. Now that was the backdrop in which Mr. Lord counsel was trying to argue that it was that the mortgage provider, and again it's an independent credit broker, had no duty or could just pick one mortgage provider. Lord Justice David Richards at 113 of Wood says it's inconsistent with the terms of those terms and conditions that the broker can just pick one mortgage provider. Again, the facts are quite different in our cases, where the brokers were not independent credit brokers, no fee, no
I think you
terms.
have already made this point, Mr. Hardwick.
The other point is, yes, about there's a suggestion that, the less knowledge of the panel, the more vulnerable the applicant, and the point that it's an objective test, we agree. There's nothing between Mr. Weir and I on the law generally. We agree the court doesn't ask about reasonable expectations in a subjective sense. But what's gone wrong with the argument, and it's, again, I'm not going to turn it up, it's 45 of the supplemental, is there's the claim that we were withholding from Mr. Wrench and Mr. Johnson, sorry, not we, the dealer, information as to the full scope of the functions the dealer was performing. That assumes that the scope of the functions did extend to selecting the best deals. They didn't. And the court knows there was no such finding. As to the engineering of less suitable deals, there is one further piece of information in the puzzle that it's important the court understands. And that is at supplemental bundle Johnson, page 4. No, sorry, page 23. I'm so sorry, page 23. And if you'd kindly, this is page 23, supplemental bundle Johnson, and it is the terms of business with Motonovo and Fastlane and TT Prestige. And if you'd kindly look at 2.1, 3/4 of the way down the page, you'll see that 2.1 under providing credit, the dealer shall introduce applicants to MNF by submitting proposals to MNF using the online system or by fax or other agreed means. The dealer agrees not to refer any applicant to any party other than MNF unless the dealer has first submitted a proposal in relation to the applicant to MNF and MNF has declined to accept such proposal. So that is a clear contractual arrangement with the bank that prevented the dealers from engineering any deals at all. They were not exercising some discretionary function in selecting deals to fit the claimant's requirements. They were not exercising any discretion. They were contractually required to introduce to the bank, which is really a complete answer to so much of the complaint about discretion. No, these were introducing credit individuals, and they had promised contractually the lender that they would give them first refusal, effectively, clause 2.1. That takes me to my very final point, about 2 minutes. And that is the point that Mr. Popplewell is going to develop in the unfair relationship arena. But one of the key arguments of the appellants is that it's 51 of the supplemental skeleton, that the brokers' dealings created an opportunity for the brokers to use their position to advance their interests, created a corresponding vulnerability. What is so important to remember in relation to the existence or non-existence of a commission is it doesn't affect the value for money, and that is using Lord Sumption's language in pled in paragraph 18. It doesn't affect the value for money of the hire purchase agreement, because the problem in the insurance contract case, in the PPI cases, was that the undisclosed commission inflated the premium. So they obscured the fact that the borrower was paying £5,000 for an insured risk, actually valued by the insurer at £1,500. That was the problem in pleading. Commissions obscure. But in a loan agreement, the statutorily required information as to interest rate and APR enables the borrower to consider the value by looking at those rates. And as to whether there's a commission or even a large commission, that's paid by the lender to the dealer. But the stated interest rate and the APR is accurate and accessible. And just finishing on that point, the court knows that the largest commission in these cases was £1,650 in the Johnson case, paid by lender to the Trade Centre Wales. But the terms of Mr. Johnson's HP agreement, we've looked at. The interest rate was 8%. The APR was about 19%. In fact, for what it's worth, one can't really compare apples and pears, the Johnson 8% is lower than Mr. Wrench's 8.75%, where the commission was £170. But I only make the point because the statutorily required information as to interest rate and APR permits the customer to assess whether the terms are value for money. And the separate commission payments do not distort or mask that value, and there is then no vulnerability created. My lady, my lords, I'm very grateful for your patience. I rest for my conclusion on paragraph 93 of my skeleton, and in the disinterested duty I have covered all the factual ground I need to. You will have seen what we say about that duty from 94 of the skeleton argument, but in circumstances as well where Mr. Wilson will be dealing with it, I'm most content to rest on my skeleton. I am very grateful for your patience.
Thank you, Mr. Hardwick. Mr. Popperwell.
My lady, my lord, I will try and be brief. I'm going to address you on the unfair relationship ground. I'm going to start by making some general comments on the appeal. I'm then going to address on the remission point, because of course the question for this court is, was His Honour Judge Jarman wrong to remit the decision below? It's not primarily whether or not the relationship is unfair, but in case you're against me on that, I will then address the allegations as to why it's said that the relationship is unfair in this case. And can I ask you to start with the order of His Honour Judge Jarman, which you will find in the core bundle at tab 8, page 143. I'm conscious you were taken to it, I think, 2 days ago, but I just want to look at exactly what His Honour Judge Jarman ordered. At page 143, you will see paragraph 2, that His Honour Judge Jarman, in fact, upheld the appeal on grounds 5 and 6. I won't take you to the grounds in the interest of time, but ground 5 was that the judge should have found that the relationship was unfair. Ground 6 was that the judge should have found that there were breaches of the conc rules, but the conc rules, you'll recall, were not pursued as separate causes of action. They were only pursued as matters that went to the unfair relationship claim. So in essence, both grounds 5 and 6 are to do with unfair relationships. So the judge upheld the appellant's appeal. Then over the page, what he did in paragraph 4 was remitted the claim to District Judge Sandacar for consideration afresh of the unfair relationship claim. And then at paragraph 5, he said as follows: in particular, but without any limitation, the judge should consider on remission the claim under section 140A(c). This court shall consider 1, whether there was any relevant breach of the following provisions of the Consumer Credit Source Book of the Financial Consulate Handbook, and the various rules are set out. But then subparagraph 2, the third line of the paragraph, whether, and if so, to what extent, the dealer-broker disclosed commission to the claimant. So this was not just a remission on whether the conc rules were breached. That was clearly a part of it, but it was also a remission on the issue as to whether And if so, to what extent the dealer broker disclosed commission to the claimant? And in particular, I praise
So, just to be absolutely clear, there is a finding that this is an unfair relationship and that Section 140A applies.
Yes, District Judge Sandercock found that the relationship was unfair, and I will very briefly take you to the reasons why he found it to be unfair in due course. But he found it to be unfair. There was a challenge before His Honour Judge Jarman, and I am going to look at exactly what His Honour Judge Jarman said and take you through his reasoning on the challenge. He dismissed various of the appellant's arguments, but he upheld or agreed with the appellants that whether or not there was a breach of the regulatory rules and whether or not the dealer had disclosed commission was relevant. The difficulty he had, which is the difficulty that this court has grappled with, is that there was no findings of fact on those matters either way, so he remitted it.
I was just asking for absolute clarity as to what you were telling us is meant by paragraph 2, the appeal on ground 5 is allowed. So an appeal was allowed on the basis that the judge was right or wrong to find that section 148 applied.
I think the judge found that the judge was wrong to find that because he should have taken into account whether or not there were any breaches of the regulatory rules, and he didn't consider that. So the unfair relationship claim was remitted back afresh to be reconsidered. So he wasn't saying the reasons that you have found the relationship to be unfair were wrong. What he was saying were there was additional reasons that the judge did not have regard to and should have done. And I'll take you to exactly what he said in his judgment.
Right.
We are in the slightly unusual position that the appellants are therefore appealing against an order which resulted from an appeal where they were successful below. And they persuaded His Honour Judge Jarman that the conc rules were relevant to the unfair relationship issue, and yet are now trying to persuade this court the contrary, because they're saying that you can determine the unfair relationship issue in the absence of considering whether or not there was a breach of the conc rules. And we also say the ambit of, so the ambition of the appellant's position is also evident by the fact they're not in fact saying you can determine the unfair relationship claim. So as we understand it, if they lose this aspect of the appeal, as we understand it, they're still saying the unfair relationship claim should go back to District Judge Sandercock to be determined, whereas no doubt they will at that point rely upon the breaches of conc rules to say that the relationship was unfair. We don't think the appellants are saying that this court is in a position to determine that the relationship was fair. They're simply saying trying to cherry pick their best points and saying, considering their best points in isolation, you can find that the relationship was unfair. And when I take you to what the court has said is the correct approach to an unfair relationship claim, I'll say, well, that's not the correct approach. You've already been taken to the unfair relationship provision. I'm not going to do it again, but we place particular emphasis in subsection 2 in deciding whether to make a determination under this section. The court shall have regard to all matters that it thinks relevant, including matters relating to the creditor and matters relating to the debtor. So there are two elements to that. It is up to the court to determine whether a matter is relevant. But once the court has determined that a matter is relevant, it is required to have regard to that matter. And we can see that that was also the decision of the Supreme Court in the Smith and Royal Bank of Scotland decision you were taken to 2 days ago. But I don't think you were taken to this passage. Can I ask you to look at the Core Authorities Bundle, tab 12, page 285. Core Authorities, tab 12, page 285. You will actually look where the red side barring is, just below E. What is more, subsection 2 makes it clear that there is no restriction on the matters to which the court may have regard in deciding whether the relationship is unfair to the debtor, provided only that the court thinks them relevant. Subsection 2 also makes it clear if any matter is thought relevant, the court not only can, but must have regard to it. And while we're with this decision, if I can just ask you, this authority, can I ask you to move on to page 289, just to avoid coming back to it in a few moments. You were also taken on day 1 to the reverse burden of proof in the unfair relationship provisions. This paragraph explains how that in fact operates in practice. You can see towards G, so just above G, it doesn't mean that the claimant is absolved from pleading particulars of claim which identify concisely the facts on which the claimant relies, nor does it mean that the claimant can make allegations of fact which the court is bound to accept unless the creditor disproves them. It is still the debtor who has the onus of proving facts on which he or she positively relies. I think it was said on day 1 that, of course, the creditor has to prove all the matters which it says make the relationship fair. I accept that, but it goes both ways. The debtor has to prove the matters that they say make the relationship unfair. And we say that once His Honour Judge Jarman had formed the view that whether there had been a breach of conk and whether or not the broker disclosed commission was a relevant matter, he was required to have regard. It would be in our submission a somewhat bold submission to say we spent 3 days arguing about dealer disclosure, whether in fact the dealer did make disclosure of commission is not a relevant matter in the context of an unfair relationship claim concerning commission in the motor finance context. If we can just look at His Honour Judge Jarman's judgment, if I may, you can find that in the core bundle at tab 9, page 153. His Honour Judge Jarman had considered the authorities, he considered Pleven. I think he'd been taken to Smith, but he applies them at paragraphs 28 and onwards. At paragraphs 28 and 29 you were taken to on day 1, that's when he deals with the Pleven issue, and I will revisit that in a few moments. But he didn't just stop at the Pleven issue. He then went on to consider other matters as well. At paragraph 30, Mr. Butters, who was counsel for the appellant, take the point that the judge was wrong to find 6.82 of those issues, namely the commission was based entirely on the amount of the capital loan, and that the lender's witness, Mr. Irving, accepted in cross-examination that the commission was paid out of the interest which Mr. Johnson paid, which was a point I think made in oral submissions a few days ago. And what Mr. Butters said was, however, there was no evidence as to the impact of the commission on interest payments, and Mr. Butters says in the absence of such evidence, the lender did not discharge its burden of proof in this regard. I pause there. In fairness, this decision predated Smith, but post-Smith, that submission can no longer stand because the burden was not on the lender to prove that the interest rates would not have lowered if the commission had not been charged. If the appellant was making the submission that had you not charged commission, the loan would have been cheaper, the burden was on the appellant to prove that. What His Honour Judge Jarman found was there was no evidence either way. It was said that, I think a couple of days ago, well, that's just a matter of common sense. If in fact you don't charge the commission, the interest rates will be lower. I'll accept it's common sense that if a lender doesn't pay commission, the interest rates could be lower, but I don't accept it would necessarily follow that they would be lower. And the witness accepted that the commission payments came out of the interest. And of course, in general terms, that's correct. It's not correct in specific terms, because Mr. Johnson's interest payments cannot have paid the commission for his agreement, because his interest payments span a 5-year period, and the commission is paid shortly after sale. But in general terms, for a lender, the money that it makes from its interest payments from its customer funds the commission payments that it pays out, because it's an overhead of the business, just in the same way that the interest payments fund all the other overheads.
And if the customer fails to make the payments under the agreement, there's usually a clawback provision in relation to the commission, isn't there?
And there is in this case. From memory, it's 4 payments, I think, in these cases. And there's also a few other things that trigger clawback. For example, the customer withdrawals or there's early settlement. There's I think satisfactory quality. So certainly there are some recoupment provisions, which is why saying commission may be payable is not actually factually incorrect. But in general terms, Mr. Johnson's specific interest cannot have paid the specific commission for Mr. Johnson. Now, if the lender takes a business decision, I am no longer going to pay commission for the introduction into my agreements, I will of course accept that it's reduced its overheads, and it is theoretically possible it could choose to reduce its prices. But it doesn't have to do so. The other decision of the lender, particularly in the absence of any market pressure to reduce its prices, is not to do so and make more money. So it doesn't necessarily follow, as night follows day, that if this commission had not been paid, that Mr. Johnson would have got his credit agreement for less money. And what His Honour Judge Jarman said, quite rightly, that there was no evidence on this either way. So, paragraph 431, returning back to His Honour Judge Jarman's judgment, when His Honour Judge Jarman says there was force at the point, there may have been force in the point prior to Smith, but post-Smith, the burden was not on my client to prove the case against him, or disprove the case against him. At paragraph 32 of His Honour Judge Jarman, I'm in the core bundle at page 153, there was a point on taking out some additional finance, which would do with the additional loan, but that didn't go anywhere. Then at paragraph 33, you can see Mr. Butters also makes criticism of the judge for his finding that none of the conc rules were breached. And he goes on to explain that. And at the bottom of that paragraph, over the page at 154, the specific rules he relies upon, 3.3.1, 3.7.42, and 4.5.3, are the rules that are referenced in the order. Says the rules that His Honour Judge Jarman, when remitting it, said they need to be considered. So he agreed with counsel, the appellants. But what he says at the top of 35 is the difficulty with this latter point is it is not an inference that the judge drew, and this is not his reasoning why the family's rule did not apply. Whether Mr. MacDonald, though he accepts there's no merit in the point, properly and realistically accepts that the judge did not make a finding as to whether the dealer did make such disclosure. At paragraph 36, there's reference to Plevin, so the judge clearly had regard to the relevant authority. The overall consideration of fairness of the breadth of section 140A of the 1974 Act involves a wide range of considerations and forensic judgment. That's paraphrasing paragraph 14 of Plevin. In my judgment, a finding as to whether or not the dealer made such disclosure may well have a material impact on the overall consideration whether the relationship between Mr. Johnson was fair. So then at the conclusion at 37, it follows in my judgment the consideration of fairness of the relationship remitted to the lower court for a finding of whether such disclosure was made by the dealer and a reconsidering the overall issue of fairness and context. It is not appropriate to remit just one or more points as identified above on this issue, given that they are all part of the overall consideration of fairness. So the point was set.
How does that all fit in with the fact that we're going to have to make a decision as to whether the commissions were half secret or secret?
You're going to have
We're
to make.
inevitably going to have to make a finding as to what was said to what was disclosed, aren't we?
There was no finding below as to what the dealer disclosed either way. That was the whole point of His Honour Judge Jarman's, the reason why he remitted it. So you do not have a finding of fact from District Judge Sandercock as to what the dealer disclosed in this case.
How's he going to do it if there was no evidence?
In terms of how is he going to reconsider it?
Yeah.
It appears, if you look at paragraph 38, because there was then a question of whether it should be remitted back to the same district judge, or whether it should be remitted back to a different. So they remitted it back, and that's the word used in the order. It actually appears what may have been consideration was a fresh trial on this issue, because of course you couldn't remit it to a different judge.
He hasn't ordered a fresh trial. He's remitted it for hearing, but I'm just thinking about the practicalities of all of this.
I looked at the language of the order earlier today. So the language he actually used sort of fits in either way, or sort of the express language used in the CPR. It doesn't neatly fall within either the rules on remitting something back for determination. He certainly didn't appear expressly to order a retrial, although when you look at paragraph 38, what appears to be envisaged was a retrial, because that's the only way you could have a different judge determining it on this issue. But even if it is just a redetermination, he's heard the evidence. He can form a view based on the materials that were placed before him and the evidence that he heard.
There was no evidence.
Well, nobody made reference to the suitability document. That was not drawn to his attention. That was not relied upon by either side. Mr. Irving gave evidence that he believed this would have happened and dealers would have had processes in place. So there is that limited evidence, and there is the evidence that Mr. Johnson...
Doesn't prove anything.
It proves his belief, and Mr. Johnson says he signed everything, didn't read what he signed.
So there is absolutely no evidence except for that one document which was signed, which we've got, and we're going to have to make our own minds up in another context. The difficulty I'm having at the moment is what His Honour Judge Jarman actually envisaged that whichever judge was hearing it was going to be doing, on the basis that there was no evidence before him at all as to what, if anything, was disclosed.
What District Judge Sandercock did when considering the conch rules was inappropriately say the conch rules didn't apply, and that was found to be wrong. And what he should have done was consider were they breached. So that he can do on the basis of the evidence before him. So in terms of the subparagraph 1 of the order, District Judge Sandercock can read conclusions. In terms of whether the dealer did and to what extent disclose the information, he will do what he can based on the evidence that he heard. And it is for him, based on the evidence that having heard Mr. Johnson, having Mr. Johnson say I paid willful disregard to the documents that I was signing, or having found that he paid willful disregard to the documents, he may well form the view that actually Mr. Irving's evidence, although light as it is to be preferred. Or maybe he won't. And maybe he'll say, I can't be satisfied either way that the dealer did anything. We simply don't know. That doesn't mean in my submission that His Honour Judge Jarman was wrong to remit it to him, for that to be considered, having correctly formed the view that whether the dealer did disclose the commission is a relevant matter, and being required then to have regard to that. We could, but couldn't, because he's in the same position that this court is, that there was no finding of fact either way. And in fairness to His Honour Judge Jarman, of course, he, I don't think, had the suitability document drawn to his attention either. Of course, what he's being asked to consider is not just whether there was a breach of conch or whether what did the dealer disclose. He's being asked to consider the unfair relationship claim afresh, because you cannot just consider one aspect of an unfair relationship claim in isolation. That ignores the nature of an unfair relationship claim, which is you have regard to all matters. And certainly District Judge Sandercock did make a number of findings which he did think were relevant to the unfair relationship claim, which we can see in the core bundle 14214. I'm not going to take you through all of them. There's a list that goes down to J over the page. We place particular emphasis on the very first of those, 65A. I find the claimant displayed an almost willful disregard of the pre-contract information and the terms and conditions of the agreement. This is shown by the claimant's statements noted at paragraphs 21L and M above. You can find those on page 205 of the bundle. M, I did not read the papers before I signed, including the dealer disclosure document. Sorry, I got the wrong order. L was in reply to counsel for the defendant pointing out clause 30.6 of the terms and conditions about commission. The claimant said, I would not have read it even if it was on the front page. So there is certainly ample material for the district judge to form a view that whether or not commission was disclosed may not have in fact mattered at all, question for the district judge. So the primary position of the banks on this appeal is His Honour Judge Jarman was quite right to do what he did, having identified a relevant matter, or two relevant matters, breaches of conc and whether or not commission was disclosed, remitted the matter back for the matter to be considered afresh. And therefore he wasn't wrong, the appeal should be dismissed on that ground alone. But if you're against me, I'm going to be very quick taking you through the allegations as to why it is said the relationship is unfair. The first one is Plevin, the Plevin argument. The short answer to this is motor finance is not payment protection insurance. The slightly longer answer is as follows. You were taken to Plevin. I just want to actually look again briefly at paragraph 18 of Plevin, which is in the Core Authority Bundle, tab 5, page 73. It was said on day one that Lord Sumption was giving general guidance. He certainly wasn't confining himself just to PPI. Well, that's right to an extent. The general guidance is given at paragraph 10, which I think your ladyship referred to on day one. But at paragraph 18, Lord Sumption is quite clearly considering the specific circumstances of Mrs. Plevin in the context of payment protection insurance. And I'm not going to read it again. You've already had regard to it. But in my submission, there are three reasons working through that why Lord Sumption found the relationship to be unfair. Firstly, because the commission was large enough to cross the tipping point at which disclosure should be made. Secondly, Mrs. Plevin did not have to take out PPI, which was an optional product. And thirdly, had she known about the commission, Mrs. Plevin would have questioned the value for money of the transaction. That's sort of the reasoning, that's the stepping stone process. If any of those matters aren't present, well then the analysis is not the same in motor finance as it is in PPI. But we actually say none of those features are present in the motor finance context. I'm going to take them in reverse order. I'm going to start with value for money, go on to optionality, and then talk about tipping points. The value for money, you've already heard from Mr. Hardwick, who has already sort of prefaced my submissions on this. The value for money in an insurance contract, such as payment protection insurance, is given by the premium. Very clever people in a room work out what's the risk of a insured event happening, how many claims are we likely to face, what do we need to charge to sort of make that a value. That's the value for money, what the premium you pay for the insurance that you get. And what happened in the payment protection insurance context is Mrs. Plevin thought she was paying X, and she was in fact paying Y. The sums were, I think she was paying $5,780 for a risk that justified the sum of $1,630. So had she known that a large chunk of her premium was going not to the insurer, because the insurer never even got the money was never paid into the insurer's hand, it was retained its source. Had she known that in fact the premium was only worth $1,630, she would no doubt have queried, why am I paying £5,780? Totally understandable. But in the loan context, the value for money in a loan is the cost of borrowing. How much does it cost me to take that money and only have to repay it back over time? And the cost of borrowing is in basic terms the interest rate. Technically it's the APR, because the APR also includes the charges, but you can probably for this purpose sort of use either terminology. But the cost of borrowing is the APR. Mr. Johnson did not need to be told about the commission in able to determine his APR or his interest rate, because he was told that in no uncertain terms in the various documentation that was prescribed by statute. You've already been taken to the pre-contract information agreement. I'm not going to do it again. So he can ascertain his value for money. He could take the product that was being offered to him, determine whether it was a good deal or a bad deal by taking the APR and comparing it to the APR from other lenders. As in fact he tried to do at the start, because he tried to get a deal, but it didn't work out for him. I want just to pause for a moment and let's just imagine for a moment, I'm going to take a step back. There is no challenge in this case that the loan was not value for money. It's not being said it wasn't value for money. But let's imagine that the appellants wanted to bring that challenge. How would they do it? Well, they'd have to do it by saying, we can see it's not value for money because he paid an APR of X and you could have got Y from the lender down the road. It wasn't value for money, it wasn't worth what you paid for it. Because if in fact the APR is comparable to that he could have obtained on the market, then it is value. It reflects exactly the deal that he could have got. And so on the value for money point, we simply make the sure point, this isn't PPI, and because of the information that is prescribed under the regulations, that the information is given, the interest rate, the APR, he's readily able to ascertain, is the deal put in front of him a good deal or a bad deal? And there is some support for that, we say, in the field decision of Nels and MRAM. If I can ask you to turn to the Core Authorities Bundle, tab 7, page 111. Again, you were taken to some of these passages on the first day. Mr. Nels, there was not, I think, a secret commission claim brought in here. There was only an unfair relationship. It said at paragraph 34, and again, I'm going to deal just to a shortcut to a few points I'll make right at the end. At paragraph 34, you can see that the Court of Appeal is having regard to that Mr. Nels was, third line, entitled to the undivided loyalty of his broker, and at the final line on that page, and that taking the advance was a breach of the duty owed to him by Mr. Nels, and was brought about by NR by the payment of it. And classic principles, Mr. Elms will be entitled to recover the amount of commission paid by NR to the broker from either them, and a reference to Wilson and Herstanger. Just pause there. We say this is clearly a statement made in the context of a finding that the broker owed a fiduciary relationship, because that is the reference to undivided loyalty, breach of the duty, Wilson and Herstanger. But that's not the point I want to make now. The point I want to make now is at paragraph 37. I do not, however, so having found that there was a undisclosed commission, having found that this made the relationship unfair, paragraph 37, the Court went to say, I do not, however, regard as appropriate to grant any further relief. The effect of the non-disclosure of the procuration fee did not mean that Mr. Nels was not in a position to assess the value for money offered by the proposed deal, as was the case in Plevitt and Paragon. So that. 36. I would accordingly require an NR to account to Mr. Nels for all of the commission it paid to the broker, which had to be half the eventual arrangement fee, together with interest and the date of payment. The rest of it, the fact if such that such undisclosed commission were not at the time uncommon, about which we were not told that the evidence does not alter the position. I don't see that alters the analysis. He was required to refund the commission, but the court clearly thought that this was not a case that fell all square with Pleasant. They was not able to ascertain the value for money. That's the value for money. On optionality, I can be even quicker. It's not in dispute that Mr. Johnson could not afford the car without credit. That was his evidence. It's referenced a number of times in this article. Everyone's on all fours on that. So he did not have the choice that Mrs. Plevin had as to whether or not to take out the product. Mrs. Plevin could have chosen not to take out payment protection insurance and still get the loan. Mr. Johnson could not choose to take the car without a loan. So he had two choices. You could either choose to take the car from a different lender, which feeds back to the point I've just made. If that's his choice, well then he has all the information that he needs to require him to do that. He can compare the interest rate, we can compare the APR, I'm not going to repeat myself. But so he has that information. Or his other choice is not to take the car at all. Those are the only choices. It's a different choice to Mrs. Plevin because in reality it wasn't optional. But if he chooses not to take the car at all, leaving aside he clearly wanted it and went out and bought it, but if he chooses that, then that leads on to the final point, which is the tipping point. So if the analysis is not that you are just considering the loan in isolation, but his purchasing decision was, should I take out the transaction as a whole, i.e. buy the motor vehicle with a loan, then when looking at the total amount he has to pay for that purchasing decision, it isn't just the credit under the interest under the loan agreement. It's the total amount for the car plus the interest, because that's his purchasing decision. And so when you're looking at a comparison of the amount of commission against the total amount payable under the loan agreement, that percentage is only 17.5%. If you want the calculations, there are skeleton argument footnote 68. So this isn't a PPI optional insurance product. If you're viewing it as well, he didn't have to take the car, he didn't want it, well, so be it. But you can't have your cake and eat it. You've got to then say, well, his purchasing decision was, how much am I going to pay for the car plus the interest? What does the commission factor in respect of that? It's only 17.5%. You were told orally that the FCA put the tipping point at 50% in terms of PPI. We're nowhere near that. I am keeping one eye at a time. I'm going to be very brief now. And just a couple of points in the skeleton argument before I move on to the final 2 points. It said at paragraph 154, the appellant's skeleton argument, that there is the fact that in the pleading context, the lender receives the commission, and in the motor finance context, the lender pays the commission makes no difference. I'm not saying it's determinative, but there certainly is a difference. One can see from the regulatory rules, the starting point is normally that it's the receiver of the commission who's due to disclose it, not the payer. My client is the payer in this case, not the receiver. It's a minor point but worth making. At the appellant's skeleton argument, paragraphs 155 to 157, it said that because the purchase of the vehicle was dependent on the credit, it placed Mr. Johnson at particular risk, because it is said that the dealer has an incentive to therefore offer credit, the maximum amount of credit possible, because the amount of credit determines the amount of commission. And this links to a point Mr. Harding made. Of course the dealer's got an incentive to offer the maximum amount of credit made, because the amount of credit is not determined by the commission. The amount of credit is determined by the cash price of the vehicle. The more expensive the vehicle, the higher the amount of credit. The credit is cash price less deposit. And so there is always an incentive for a motor dealer to offer or to obtain the most amount of credit possible, because the motor dealer is always going to want to obtain the highest price possible for the car that it is selling. And so even if the commission was completely removed from the scenario, that wouldn't alter the incentive for the dealer to try and get the most amount of credit for the customer, because the practical reality is it just means it's making more money on the car. At paragraph 159 to 160 of the appellant's skeleton argument, the point is made, or had Mr. Johnson known what was happening, he wouldn't go ahead with the transaction. The short answer to this point is, well, His Honour Judge Sandercock made a finding that he was wrong in this regard, and while that was sought to be appealed before His Honour Judge Jarman, it's not being appealed before this court.
Sorry, which fact finding?
It's said that had Mr. Johnson known about the commission, then he wouldn't have gone ahead with the transaction. District Judge Sandercock found that he was mistaken because he had misunderstood the commission arrangements. That was appealed before His Honour Judge Jarman, that finding of fact. But His Honour Judge Jarman did not uphold that aspect of the appeal. And that was not a ground of appeal before this court. Briefly then on the Nels point, and I am very nearly finished. Reference has been made to section 56 of the Consumer Credit Act, which makes a negotiator the deemed agent of a creditor for the purpose of the Consumer Credit Act. The concession was made below that section 56(1)(c) is applicable. I don't seek to go behind that concession, but I simply want to make it clear that the concession was made on a very explicit basis, which was that it was given because of the effect of the personal loan in the Mr. Johnson transaction. And it was expressly said in the absence of the personal loan that concession would not be made. So we just don't want to be given the impression that we are conceding section 56 is always applicable. That is not the concession. On Nels, incredibly briefly, I think what's said is, if a finance company is liable for payment of a half-secret commission, then it follows that the relationship is unfair. But if that's what's being said, I readily accept a finding that if a finance company is liable under a half-secret, or even a fully secret commission claim, that is relevant to an unfair relationship claim. I don't say it's determinative. You can see that in the approaches of some of the various judges in the authorities bundled before you on the fully secret claims. The first instance decision of Wood and Commercial Birss, Mr. James Pickering did find that there was an unfair relationship as a consequence of the undisclosed commission. On appeal in the Pengalian Business Mortgage Finance, Marcus Smith J, while he upheld the appeal in respect of the secret commission claim, he did not uphold the appeal unfair relationship claim, finding that the judge's conclusions on whether the relationship was unfair were unimpeachable, notwithstanding the fact that he had found there to be a secret commission. Or Deputy District Judge Wrench, in the Wrench claim, adopted a third route and said, well, I don't think I need to consider that, because I found there to be a secret commission. So I'm not trying to say it's not a relevant factor. Clearly it is. If the court finds that a lender has, whether it be paid a bribe or paid a halfway house commission, which gives some other form of relief, that is something to be taken into account. It's not determinative, it's one of the factors that goes into the mix. And again, that is something for the judge to consider. And if it's being said that even if the lender does not have liability, in any event the relationship is unfair because of the payment commission, basing that on Nels, I simply say that is not what Nels says. And I took you to the paragraph a moment ago. It's quite clear in Nels that the decision is based upon there being a finding of a breach of fiduciary duty and a Herstanger type of claim. And I simply say the key paragraph is that you deprive a broker of its undivided loyalty. I say you cannot deprive somebody of something if they do not owe it in the first instance. Those are, in respect of ground 4, the bank's submissions.
Thank you very much.
Unless there is anything else from Mr. Hardwick, we can hand over to Close Brothers.
Yes, thank you very much, Mr. Popplewell. Mr. Wilson, been very patient.
Thank you, my lady. I have been rather squeezed here.
Well, we might truncate lunch, if that would help.
I think anything would help. At the moment, I have to say, I'm having difficulties in seeing how I'm going to get through everything in the time available and still leave Mr. Weir, who's perfectly entitled to have a period of time to reply. But
well, I have to tell you, we can't sit late tonight because of other commitments.
Yeah. Well, we'll see how we get on. We may have to consider our options, including putting some of this in a short supplemental written note. There may be other options.
I'm just very keen that you shouldn't be squeezed, because
No,
Mr. Weir's had a very long time, Mr. Hardwick's had a very long time, Mr. Popplewell has been very efficient, but you haven't had a chance to say anything yet.
I'm grateful for that, lady. And obviously, it's not just what I want to say; it's what my clients and solicitors expect me to have an opportunity to say. So, I will make a start, and I suspect with a slightly truncated lunch, we'll get through most of it, and we'll see. Very broadly, there's two parts to this. There's the short. I was going to call it a short and long answer, but perhaps I'll adopt my learned friend's terminology. There's a less punchy answer, and there's a more punchy answer. The less punchy answer doesn't involve a challenge to Wood. It's very much on the facts of this case, and I do need to emphasise, and I will be dealing with this in some detail, the facts of my case are distinct, and there's a danger in lumping all this together just because it's conjoined appeal. That's the first part of the sense of submissions. The second part is the wider challenge to Wood, and I want to say at the outset that even if this doesn't result in there being a departure from Wood, I hope that the submissions I can make about that will at least give rise to some assistance in terms of interpreting Wood. And I'm very conscious that this court is mindful of giving guidance to the lower courts in that respect as well. So that's how I'm shaping my submissions. So I will launch straight into the more factual answer. We know that the district judge obviously decided that on the facts of this case, the Wood duty was not owed, and I emphasise on the facts of this case because as I say, there is a danger in conjoined appeals of making generalities and losing sight of the individual facts and individual findings. The appellant submissions have rather lumped the appeals together, and I understand why he's done it that way, but it has resulted in a number of assertions that are really generalities, and I say aren't without proper foundation insofar as the Hopcraft case is concerned. And what I'd like to do is start by identifying some of the assertions that are made against me and against Mr. Hardwick generically, and then compare those with what the actual findings and evidence are in the Hopcraft case very specifically. And if I can do that by reference first to my learned friend Mr. Weir's skeleton argument, which is of course at the very beginning of the core bundle, tab 1, page 10. This is not all of the assertions against me, but just some of the key ones. Paragraph 18. They say that at the bottom there, that the broker's role required them to source a finance deal that would be suitable for the claimant's requirements. And then at the last sentence, the brokers were responsible for selecting one or more deals from their panel of lenders to present to the claimants. Paragraph 19. The brokers were duty-bound to inform the claimant of the most competitive or the best deal. Paragraph 21, they say the claimants were, and they're dealing with all the claimants generically, were financially unsophisticated, although they go on to accept that there was no direct finding to that effect in the judgment in Hopcraft. Then if we go back to paragraph 14, they say at the beginning there that each claimant assumed that the broker's only source of revenue was the profit on the sale. And we'll see at the end of that paragraph, this is an example of them deriving that from the witness statement of Miss Hopcraft, which we have to be very careful with in our case, and I'll come back to that. And then there's a few more in the supplemental skeleton argument, which is at tab 39, back, page 455. The top paragraph there is 36A, and within that you'll see that it said that the broker canvassed finance deals on the claimant's behalf from its panel of lenders. And then page 459, paragraph 48, in the second line, the weight of the evidence in each case supports the conclusion that, and he's saying the claimant knew that the brokers could select finance from a panel on their behalf. And then in the last line, in Hopcraft, the only sensible inference from the defendant's evidence is that the claimant knew at the time that the broker was sourcing finance from a panel. And we'll see that in fact those propositions fly in the face of the factual findings made below. And one of the points to bear in mind in this appeal is there was no challenge to the factual findings that were actually made in my case. And then just to finish this off, at paragraph 55, at page 462, we see an example of a pick and mix approach, as I would call it. This paragraph starts by making a general proposition about the commission being derived from the customer, and then relies on evidence only in in the Johnson and Wrench cases, without any reference to the evidence in Hopcraft. So as I say, the court needs to be careful with these assertions. The evidence in Hopcraft was very limited, and that is hardly surprising. It's the oldest of the cases. It was a transaction that took place over 10 years ago. And when one does look at the findings, we'll come to this in just a moment, but in summary, we'll see that there was no finding that what Jordans were actually doing, Jordans was the car dealer in my case, there was no finding that what they were actually doing or purporting to do was finding the most suitable deal, the best deal, the most competitive deal, or anything of that sort. There's no equivalent to the suitability documents that we've seen in other cases. There was not even a finding that Jordans actually made a selection from a panel in this particular case. And there was certainly no finding that Miss Hopcraft knew that Jordans was making a selection from a panel or had access to a panel. That's not even said in Mrs. Hopcraft's witness statement, which in any event you'll see was essentially rejected. But can we do this more systematically by looking at the judgment below, first of all, which is in the core bundle at tab 36. This is the judgment of Deputy District Judge Morris. Court be aware this is a leapfrog appeal. And we can pick it up, please, at page 400. He starts by saying something about the core facts. If we just look at the first, it picks up from paragraph 11. Now, my learned friend read 11 to you, but may I go over it again? The core facts in this case are not particularly contentious. The claimant wanted to replace her vehicle. She found one she wanted at Jordans, well-known motorship dealership in the Hull area. She had a small part exchange from the vehicle she was already had and a small deposit, but she did not have the ability to pay the sort of price for which she was looking, and she was going to need some sort of finance. She therefore required HP arrangements, and Jordans arranged these hire purchase arrangements with the defendant. And there's no reference to any other lender there. The claimant, signed the necessary documentation and agreements which made no mention of any commission, but the commission was in fact £183. The finance agreement, the HP plan, was repaid in full by the claimant, and I indeed think she paid it early in September 2016, but 8.5 years later, having consulted the solicitors, a letter of claim was sent alleging secret commission and so on. And just for your ladyships and lordships note, just to help, I'll give you the uncontentious remaining facts, which aren't so clearly set out there, but there's no issue over any of this. The date of the agreement in my case was the 10th of January 2014, and that's pre-regulation, and I'll come back to that point. The price of the car, by which I mean the total cash price of the car, was £8,530. Miss Hopcraft paid a deposit of £250, so the remaining £8,280 was on credit, and the total amount she paid overall, including the cost of credit, in other words, including all the interest, was £11,350. And as we've seen, the commission was a single payment of £183. In fact, it was 183.26 to be precise. We calculate that to be 2.21% of the amount of credit advanced. And then, if I may, I was going to carry on with another part of the judgment, which takes me over to page 403. Where the judge starts to consider the actual evidence, as he says, and you were not shown this part by my learned friend Mr. Weir. He says, so what is the actual evidence of the relationship between Jordans and the claimant in this case? I heard from the claimant herself and of course read her statement. The written statement says all the right things to justify this claim to be in line with the authorities as developed in Commercial First, reference to Wood. And then he summarises, but without accepting what is said in the statement in the rest of paragraph 28. But then in paragraph 29, he says, however, even on first reading of the statement, I could not help think that the claimant was saying what she expected me to need her to hear, and to be heavily influenced by hindsight and consideration of her position since the issue of this litigation. This was further compounded by the defendant producing from another very recent case in which the same defendants are involved, and I believe the same claimant solicitors are involved in a similar situation of a statement, redacted as possible, where Auto Trade were the car dealers and where the statement was in very, very similar terms, to the point of exactly the same wording as in this case. Yet further, in the claimant's statement from my case, on at least 2 occasions, paragraphs 4 and 30, she refers to Marshall's rather than Jordan's. Otherwise, she gets even the name of the dealership wrong, which suggests to me that this is a formula-based statement, as Marshall's are, of course, also a well-known car dealership. And then at 30, you'll see what's said there, and the last 3 lines, he's still criticising the statement. It's not just a couple of lines. The defendant highlighted virtually 20 instances of the same sentences and even paragraphs in the 2 statements which were produced to me, being the claimant's own statement and one from an Auto Trade case. Now, of course, then he refers to the cross-examination of the claimant, who he says stated in paragraph 31 that the statement was typed by someone else who extended, I think were the words she used, what the claimant has said. So I mean, it becomes clear from this that the judge isn't prepared to rely on what's in the statement and only what he hears from Miss Hopcraft in person under cross-examination, which he deals with at paragraph 32. In fact, when it was examined in cross-examination, a slightly different position arose from the claimant. There were no terms and conditions in relation to any finance dealings between her and Jordan's. There was no payment by her for Jordan's services, if any, in introducing the defendant finance company, and she acknowledged that she thought various things and assumed various things. She says, and this is very important, she says Jordan's did not talk about other finance companies other than the defendant. This simply cannot be squared with the things we've just seen in my learned friend supplemental skeleton, in particular paragraph 48, where he said the evidence demonstrates that Miss Hopcraft knew that Jordan's was making a selection from different finance companies on the panel. They did not talk about other interest rates or the status of parties or any other borrowers or the details of potentially different arrangements. Paragraph 33, she assumed, she said, you'd get the best deal. And that's, in inverted commas, that's just a quotation from the witness statement. She says that they simply sorted out the papers overnight and her father went the next day to sign up, being introduced as a guarantor. But he wasn't exactly a guarantor, as that's made clear in paragraph 34. Now, my learned friend, Mr. Weir, read the first sentence of paragraph 34, but not beyond that in this paragraph. He read, at the time of this transaction in 2014, the claimant was a 22-year-old student nurse with a part-time job. As I've noted, she already had a car. I think it had been provided by her father, but she needed to upgrade and she was clearly keen on the car she saw and bought from Jordan's. I can accept that she was a little naive and perhaps vulnerable in some aspects, but, and this is the part that was not read out to you, but it is clear to me that she was focused on buying the car. And as long as the monthly payments were about right, and I say about right because she actually agreed to pay more than her apparent budget, she was happy with the situation. Tellingly, she acknowledges that her father had more experience in life, in the world, in cars and in finance. And yet I have no statement from him, even though he was brought in as a party, because he was a party to the finance agreement, and he was involved in matters before the hire purchase agreement was completed and signed. So when I said he's not a guarantee at all, it was simply a joint, they were joint borrowers, joint purchasers, as far as the documentation was concerned. Now, pausing there before I go on, we've seen, we can see immediately the dangers of making generic comments. I've said already, it can't be understood, we can't conclude, my learned friend can't conclude, that Miss Hopcraft knew and understood that Jordan's were making a selection on her behalf from a panel. That these findings don't even include a finding that Jordan's did make a selection from a panel. It might have done, but there is no finding to that effect, and we'll come back to that point when I look at some of the evidence. But just carrying on with this for the time being. Paragraph 35, he refers then to the one witness statement from Close Brothers, from Imogen Shaw, and says this: to a great extent, she is only an administrative witness, in that she was not involved with this particular HP transaction. And indeed, I do not think she was even employed by the defendants at the time. And she simply makes broad comments about the defendant's obligations and responsibilities at the time, and how it is likely that the HP transaction proceeded. And then we can skip 36, and from 37, it moves to a more evaluative stage of the judgment. And he says, we've seen this resonates with some of the other decisions at the county court level. At the end of the day, Jordans are motor dealers. Their primary role is to sell cars. And then the last three lines of that, they, like many motor dealers, are licensed to arrange finance, but they are not independent brokers or commercial brokers of the car purchase. They act as intermediary to facilitate the sale of the car from which they make their primary profit. And then in 38, third line down, I accept in the words of the claimant that they had a common goal in facilitating the finance to allow the sale to proceed and to perhaps make a commission as well, but that hardly makes them impartial or disinterested in the matter. Indeed, the common goal aspect implies to me that it is either part of the contract for the sale of the car or ancillary to the sale of the car, and as such they are certainly not impartial or disinterested, and they want to effect that sale, and that rather chimes with some submissions that my learned friend Mr. Hardwick was making. But the point I'm focusing on at the moment is there was no finding here that Miss Hopcraft was looking for the best financial deal or the most competitive deal, or that she told Jordans that that's what she expected of them, or that Jordans told Miss Hopcraft that they would be making a selection from a panel, or that they would be finding her the best or most competitive deal, and there's simply nothing to that effect. So, in those circumstances, my learned friend goes and has shown you some of the underlying evidence, and I want to do that too, starting with that statement of Miss Hopcraft that's just been referred to. But I'm not going to go into this in any detail because, as you will have seen, that statement was rejected essentially as being little more than a template. For completeness, we can turn to it in the Hopcraft supplemental bundle. At tab 1, page 1. And we can see if we scan through on page 3, paragraph 4, the erroneous references to Marshall that the judge had alighted upon.
I think we can readily see that there was a degree of templating going on both sides, the lenders as well.
Yes, that's true. And one could equally say that Miss Hopcraft's, Miss Shaw's statement wasn't particularly relied upon for that reason. And in fact, let's see that.
You don't
tab
need
2.
to go there, but I mean, I think it's accepted.
Yes, but it is important this because my learned friend tries to draw quite a lot out of Miss Shaw's statement. That's at tab 2, and I would like to go to that, please. And I think to underline the point that the ladyship was just making, we see at paragraph 1, in the middle there, of that paragraph, she said, I first joined Close in December 2016.
So 2 years later, yeah.
And I had no direct involvement in the transaction. But my learned friend relies very heavily on it, notwithstanding that, on paragraphs 9, 10, and perhaps 11. So we should look at those. My learned friend invited you to read all of paragraph 9. But looking at this carefully, what Miss Shaw is addressing here is obviously, as your ladyship says, simply a standard sales process. She doesn't say that she knows that this was the process in operation in 2014, but the assumption seems to be that basic process hasn't changed. And the first half of this is really saying no more than that the dealer would have obtained fairly rudimentary information, what deposit she wants to pay, how much she thinks she can afford to pay each month, how long she wants the vehicle for. Now, this is nothing like the impression that my learned friend Mr. Weir was conveying of a broker obtaining intimate and confidential information about personal financial affairs with which he is then entrusted and sent effectively to go out and canvass on her behalf. That's not what's being said here. And then the second half is talking about something different again. It's talking about Close Brothers' own requirements in terms of its assessment of affordability. Close Brothers specifically require customers to provide 3 years of employment and an address history in addition to affordability information before any proposal submitted by a dealer can be considered.
I read that as meaning that she's describing what the dealers that have a relationship with Close
Yes.
Do, and what Close would expect them to get from the customer.
Exactly. Yeah. For the purposes of Close's assessment.
Yes.
We're not disagreeing with each other at all. Now, there's no evidence here of the dealer being asked, however, to provide or ask the kind of questions about what kind of finance products, from which kind of lender, what would be most suitable. There are no questions about whether the lender wanted the lowest monthly payments, lowest overall costs. Now this is important. These could be two different things. Sometimes lower payments over a longer period of time are required, but that can mean a larger overall financial cost. So it depends what the customer wants. If a broker in this situation is truly supposed to be engaged in a delegated function of finding the best deal for Hopcraft, it begs the question, well, what are the parameters? It would need to understand from Miss Hopcraft what she would consider to be the best deal, what's important to her, the interest rate, the monthly payment, overall cost, perhaps how long it would take her to obtain ownership of the vehicle. And we do see those sorts of questions asked in other brokerage contexts, of course. But that requires a much wider range of questions. It requires more information about personal financial circumstances and the requirements. And of course, post-regulation, we have concepts of demands and needs, and that's a widely used term, and it connotes all those sorts of requirements. There's an investigatory stage to go through, but there's nothing like that here. It's really just, look, what car do you want, what deposit do you want to put down, and what monthly payments can you afford? Yeah, exactly. So then if we go to paragraph 10, now paragraph 10 is critical for my learned friend because this is the only reference to a panel of lenders in the whole case. But what is paragraph 10 really saying? It is talking about a really very simple process. It is simply giving the description of how the dealer enters basic information we've just been talking about into the computer. Miss Shaw says this is likely to be code weavers, and it may be, because I don't know, that may have been the most common system used. But all this is really telling us is that the system may have involved a number of lenders at the other end receiving that information. She's not saying that code weavers would necessarily provide, or was there to provide, the most suitable and most competitive product, or that the dealer's function was to do that, to try to find the most competitive answer from one with the lowest interest rate. And see, built into the case against me is a really key assumption about why is this panel of lenders, if it was ever in fact used in my case, which isn't entirely clear, why is it there? In my submission, we cannot conclude from the limited evidence in Hopcraft that the panel, if it was used, if it was there in order to provide a range of options for the benefit of the customer, from which the dealer would then make a selection on the customer's behalf. As I think my learned friend Mr. Hardwick alluded to this, it could equally be there for the dealer's benefit, to give it, the dealer, a better chance of finding a lender who would be prepared to finance this car. or this kind of car, or at this kind of price range, or perhaps on this kind of arrangement. This is a hire purchase arrangement. There could be different lenders with different appetites across that spectrum of car values, across the spectrum of different kinds of customer. Again, I think Fred has alluded to this. Some lenders are happy to lend to subprime borrowers, some aren't, and so on.
Provisional drivers and so forth.
Exactly. Now, in a sense, I'm driven into speculation here, but it's no more speculative, this is the point, than my learned friend's assumption that the purpose of having a panel in Hopcraft was to provide the customers with lenders, in effect, in competition with each other over any one sale. We just don't know that. Can I just finish this what I have to say about this statement, and then we can break for the short adjournment. Paragraph 11, she says it's probably under the same Codeweaver system that Close Brothers replied with a proposal. And then in the last 6 lines of paragraph 11, this says a number of other offers may have been sent to the claimant. And note this is to the claimant, not to the dealer, by different lenders. However, Close are not able to confirm this. All Close Brothers know is what they see from the receiving end of all of this, which is they get a proposal which they're prepared to accept, and they pass on via the dealer, and I'll talk about it being in an administrative capacity after lunch, but that effectively that's passed on for Miss Hopcraft to accept or not. In fact, of course, she did accept it here. And we see, again, if one looks at paragraph 12, what's clear from what's being said here is that it's Close Brothers, not Jordan's, that put together that paperwork. And there's no suggestion that Jordan's even have a role in filling out that paperwork. They present it to the customer. I think I can leave that statement there, and that's probably as good a moment as any.
Yeah.
Well, with apologies to the staff, but if you don't mind, we'll resume again at 2:45. Is that all right? Thank you very much. I'm sorry to cut short your lunch hour, but we are going to do our very level best to get through this as much as we possibly can.
Thank you, Mark.